Okay, we now have a quorum and we'll begin the closing the Justice Gap Working Group meeting. This meeting is being recorded. Before I take roll, we ask that anyone who plans on giving public comment to use the raise hand function to indicate that you'd like to do so. Now, with permission of the chair, we'll take roll.
Thank you. Yes.
Okay, Justice Tucker.
Here.
Mary Baldwin.
Here.
Becky Sandifer.
Here.
Marta Alkenbrock.
Present.
Andrew Arruda. Wendy Chang. David Engstrom.
Here.
Dan Grunfeld. Eric Helland.
Here.
Kathy Huang. Micah Star Liberty.
Here.
Kevin Moore.
Here.
Wendy Musell. Lucy Rica.
Here.
Toby Rothschild. Patricia.
This is Wendy Musell. I'm here.
Oh, hi, Wendy. Okay. Patricia Scutiero.
Here.
I don't know if I called Toby. Sorry, I got distracted. I don't think Toby's here. Sacha Steinberger. Betty Williams. Lori Zila. Okay, thank you. Oh,
Okay.
thank you, Lori.
So we see Lori. So even if you didn't hear her, she's
Yep.
here.
Got her.
I didn't hear from Wendy Chang, but her screen is up.
It's actually Wendy Musell. I didn't know which Wendy it was when she
Well,
logged.
I believe both Wendy's are here because I see Wendy Musell's name and I heard her voice. I saw Wendy Chang's name, but I did not hear her voice, but I did see she was on mute. So
No, that was actually Wendy Musell. When Wendy logged in, she only had her first name, so I thought it was Wendy.
oh,
Chang.
I see what you're saying. Okay, so we don't think that Judge Chang is with us.
I know she's in trial. She said
Got
she
it.
was going to try to make it, but she wasn't sure.
Got it. Thank you. I'm glad we have Ms. Musell correctly captioned now.
Thank you.
Okay. Then let's get started with public comment. Do we have people who've indicated they'd like to provide public comment?
Yes, we do. Betty, you'll be given 2 minutes.
I haven't heard Betty yet, but if we could hear Betty, and also Betty, if you could give us your last name, that would be helpful. We keep a record of who presents to us.
Hi, this is Betty Williams. I'm trying to log in, but I'm not finding the right Zoom link. I can see.
Oh, sorry.
Aha.
I can go ahead and I can just promote you.
Thank you.
All right, so Betty Williams is a member of the task force and will reflect that she is present and with us.
And we have no other public comment.
Okay. Then let's do the staff report.
Okay, thanks. So we have a couple updates we just wanted to give you. We sent you an email a couple weeks ago with a letter that the Board of Trustees chair and the executive director of the bar had sent to the legislature about our fee bill. So just to give you a very brief overview, every year the legislature passes a bill that allows the bar to charge fees, assess fees to licensees, to attorneys every year. And in that bill, this year in June, the legislature put some amendments into the bill that impacts the Closing the Justice Gap Working Group. And so the Senate Judiciary had a committee had a hearing in June. They voted to pass the bill out of committee as it was written with those amendments in June. And then the State Bar staff has been negotiating, as you saw with the letter that we sent, to try to get some clarity about what it is that the concerns of the legislature are, and try to see if we will have some different language in there that will allow the working group to keep going. So right now we don't have any updated language. Nothing's been amended yet. We're still in conversation. There have been the press has been active in this, as you may have seen. The LA Times and the Cal Matters have put some editorials out about it, and some other guest, commentary has happened. But as of now, we're still waiting to find out when the bill will be on the Senate floor and whether there will be additional amendments. So I just wanted you to know that's where we stand. Unfortunately, we don't have more specific information on that. And then, does anyone have any questions about that before I move on?
I do.
Sure.
So as I understand it, the state bar proposed an amended language to the funding bill. Was that language accepted?
No, not yet. No, nothing's been accepted. So there have been discussions with staff and they're working through it, but nothing has been, the bill has not been amended.
So it also, as I understand it, then if the bill is passed, this working group will no longer be allowed to be meeting at all, correct?
Possibly, yes. It's hard to, we're still trying to understand exactly what the intent of the language is, but it does appear that that could be one of the options, that the working group would no longer be able to function.
And is it correct to say that as of August 31st, the governor is going to sign the final bill language?
Usually, so the legislature has until the 31st to get it to the governor, and the governor has, I don't have the date off the top of my head, but usually it's like the end of September, early October to sign bills. So we don't know exactly when. And then unless there's urgency language written into the bill, it technically doesn't take effect until January 1st. But that's the way that the legislative process happens. You know, depending on what ends up in the bill, we'll have to make decisions about what to do.
Is there urgency language in the bill as it is?
Not right now. Not right now, there's not.
Is that being proposed?
Not that I know of.
Has the state bar requested any additional language since the last language was rejected by the legislature?
Well, it hasn't necessarily been rejected, but there's just still conversations happening. Nothing has been amended now, but there's still discussions going on. But that's all I know. We don't have anything that's been accepted yet.
Is there a reason why this meeting is going forward with the substantive issues that seem to be on the agenda? Is there a reason why this meeting is going forward when it appears that this group will no longer be able to function? Should the bill as presently constituted essentially wipe out this committee?
I'm going to jump in and answer that one, Marta, because it's a very good question, and I was intending to address it after Bridget's report was finished. We don't know yet what the legislature is going to do. We don't know whether we will be meeting in September. We don't know whether we will be meeting after September. We just don't know what they're going to do. But they so far haven't done anything yet. You know, the legislation hasn't passed yet. So we don't know what the future holds. And I thought, because we don't know what the future holds, that the right thing to do was to go forward with this meeting, to make decisions today based on what we think of the work that we're you know, the issues that are on the agenda for today, and to make the progress we can today. After today, I think it's very much an open question. And we will obviously all be watching to see what the legislature does, and we'll react accordingly, although it's hard for me to say what accordingly is because I don't know what the legislature is going to do. But I think you raised very good questions about the future. And the question about what it means for today is that we should do the best work we can today, understanding that we don't know whether it will be the last meeting we hold or whether it will simply be, you know, the last meeting we hold in August, and September we'll keep going. Just don't know yet.
Well, given the uncertainty that is surrounding this committee and its future, I'd like to make a motion that this meeting be adjourned until after the August 31st.
This is Wendy Musel. I would second that motion. As the legislative appointee, there's some significant concerns that the legislature has expressed, and I think that those are expressed in the bill, which has not yet been amended in any way. And I think it's premature for us to be moving forward, given the significant concerns that the legislature has expressed consistently.
Okay, I think this is a serious motion that we do need to, I guess, ask whether we can address it since it wasn't on the agenda, but I can understand why it wasn't on the agenda. I don't know whether we can address it or not, but I do think it would be appropriate that we conclude the reports and move into the action portion of our meeting before we entertain motions, and that will give our bar staff, Brady, I'm looking at you, a chance to figure out what advice to give us about whether we can consider this motion under the circumstances, even though it wasn't on the, even though it wasn't.
Give me 5 minutes.
Okay, so we're going to continue just with the informational piece before we get to any action. We will hear from Brady and Marta's proposed motion.
Okay, I see a couple hands, but are they, should I?
Presumably on this issue, so I'm going to call on Kevin and then Micah.
Okay,
I defer to Micah because her hand was up before mine.
Oh,
by
sorry, I got
several
that
minutes.
backwards.
Either way, but I'm happy to go next. Thank you, Kevin. I'd like some more details about who is engaging in conversations about potential amendments with the legislature and with whom in the legislature they're having these conversations. And I have
Okay.
follow-up questions, I'm sure.
well, I don't, okay, that's fine. I mean, our board chair, Ruben Duran, is involved in these conversations. State bar staff, legislative staff is working with the staff and the members of the judiciary committees.
So, but like, who are the human beings? Do we know their names? I'd like to know who are in these meetings and who are actively engaging in the negotiations.
Okay, well, our executive director, Leah Wilson, and Donna Hershkowitz is the chief of legislation, and I'm the deputy chief of legislation, so I'm working in that arena as well. So the three of us, mostly Donna.
Is the state bar, has the state bar engaged any lobbyist to help in this issue?
We have a lobbyist that works with the bar in general. So yes, our lobbyist, Jennifer Wada.
Okay, anybody else?
No.
Has the state bar hired a PR firm related to this legislation, engage them to do any sort of activity related to this legislation?
No.
Has the state bar asked any members of this committee to write op-eds?
So Micah,
Thank you.
I realize you have a lot of questions, but I'm not sure that it's appropriate to ask Bridget to speak on behalf of the state bar on all of these points.
Well, then whomever can answer these questions is fine with me. I was just asking Bridget because I thought she was the one who was most appropriate since she gave the report.
She is the one who's most appropriate at this meeting at this time, but I just want to flag the fact that that I'm going to leave up to Bridget how much of this she feels she can answer.
Yeah,
I'm because you don't have the information, or because you
when it
don't
comes
want
to communications, you can talk to our director of communications, Teresa Ruano. She's the one that can answer all of the questions about communications.
Okay, then I'd like to have that person participate in this meeting, because I, like Wendy and Marta, am very concerned that this meeting is even happening. And when we are getting reports that don't have a lot of detail about lobbying efforts, I'd like someone to be able to answer our questions.
Well,
Okay.
we sent you the letter. We circulated the letter that we sent to the legislature. That was what we sent, and that was the proposed language that we sent. So you have that information. Beyond that, we're not going to get into all of the discussions right now about it.
I have a right to know as a member of this committee?
I've given you all the I've given you the information that we have right now to share.
I'd like an answer to my question, though. Do I have a right as a member of this committee to ask these questions and to get answers?
Micah, you've asked your questions and you got the answer from Bridget just now that that's all she has to share on that subject. If you have something, if you have a specific question.
This is a problem.
Micah,
No. I'm allowed. Hold on, Justice Hooper.
I'm going to let you continue to pose some questions, but I can't make Bridget answer them if she doesn't think she's appropriately placed to do so.
Then I would like the state bar to have someone join this meeting so we can get answers to these very important questions.
I understand that is your desire. What other questions or points would you like to make before I call on the next person?
You can call on Kevin now, but I want those questions answered, please.
I understand. Kevin.
Okay, my question was really about a process question.
Okay.
And it's sort of a tag along on what Micah raised about what is the process for us to go about actually writing an article, whether it's an op-ed article or writing, whether individually as members, although not representing the committee, to legislators. I've seen a couple of articles out there that are telling legislators that they should not so much back off, but that they should not inhibit the ability of the state bar to how shall we say this, explore alternative methods of delivery of legal services. And I'm generally in favor of that, but I've also gotten the impression, first when I was on ADLS and now when I've been on this committee, that we pretty much shouldn't be doing that for fear that we might implicate the public's right to know, and perhaps having exchanges with other members of the committees when we do this. So I am just simply asking, what is the mechanism now for permitting that? Whether it is somebody might want to say something, well, let's take it easy. Let's not go too far right now. We're not trying to go too far. But as far as individual efforts, whether pro or con the work of this working group, I'd like to know, what is the bar's position on how individual members should present the issues to the public? And I can wait until somebody else comes here later.
So Kevin, I think that's a very important question. I'm going to answer it in the first instance, and then I'm going to call on Brady, because Brady has the lawyer's answer. But as the chair of the committee, I have never asked, and frankly hadn't thought it would be appropriate to ask members of the committee to muzzle themselves and to not talk to the press or not talk to their colleagues, their constituents, their friends, their whatever. So I'm not making that request now. I think if you want to write an op-ed piece, or if any other member of this group wants to write an op-ed piece, you definitely should do so, and that you are free to mention that you are active with this committee, although you obviously need to be careful in the way you write, that it's clear you're not speaking on behalf of the committee. And that's the only response that I would give, but I want to ask Brady if he has anything to supplement.
Sure. The only addition, that's all true. Obviously, you're not speaking for the committee or the state bar. Is if you start getting together with a group that ends up being more than half of this committee, then that becomes a Bagley-Keene violation. So you want to either do a small group, or we could look as a group into considering communication on behalf of the committee, but that would need to be done at an open meeting.
Okay, thank you.
Marta. You're on mute.
Following up on what Kevin just said, and also Micah, with respect to, I noticed that as of, I think just this week, David Engstrom and Lucy Rica published an article in Cal Matters on their thoughts and opinions relative to the dues bill and what was transpiring in the legislature. And my specific question is whether or not they were contacted by state bar staff and asked to submit an opinion piece in Cal Matters, or if this was something that they did on their own. And my final point is, when on our very first meeting, as I recall, we were asked by state bar staff to if we were contacted by the press, to keep them in the loop with respect to any comments or requests that they were made by the press with relative to the work they were doing in this committee. So I just wanted to make sure that my understanding was correct with respect to that. And that's in response to Justice Duker, your comment. But I just want to know if anybody specifically from the State Bar staff is asking particular members of this group to write opinion pieces that have been published in a variety of articles in the last several weeks.
So Marta, thank you very much for raising that point, because I had completely forgotten, but you have now reminded me that we were asked to, I don't remember the specifics, but I'm going to turn that back to the bar staff and ask, I don't know if there's a policy and you remember exactly what you told us. Is Marta exactly right about what we were told? And is that still the policy?
Randy, do you want to answer that about the policy?
Sure.
I know we had that at the beginning.
Yeah, for sub-entities, the Office of Professional Competence of Staff, including COPRAC, the ADLs, the Working Group, the Rules Revision Commission, it's always been our practice to inform members of the committee that while they don't lose their individual right of free speech to speak their mind, that if they're contacted in their capacity as a member of a State Bar sub-entity, that they should keep our Office of Communications involved. And if they wanted to defer to the Office of Communications to assist or to field inquiry for anything for attribution or quotation or an interview, then they're happy to do that. If the member wanted to speak in their own voice, then our request was that that be clarified so that the media representative and the readers of the piece would know that they're expressing a personal viewpoint and not speaking on behalf of the board of the State Bar. And that's my understanding of the standard practice. And I think that's probably what we gave you at our orientation some time ago.
That's right.
Anybody else want to comment in response to Marta's comments and questions before we move to Wendy?
My first question wasn't responded to. I just want to know if the State Bar staff.
I understand, and I don't know whether anyone wants to offer a response in this meeting, but I'm giving them the opportunity to do that.
I can have communications come on. Well, we can see if somebody from communications can come on in general, but no, we did not ask anyone on this committee to write an op-ed.
Any other comment before we move to Wendy? That's specifically in response to what Marta has just raised. Seeing no hands in response to that, I'm going to ask Wendy for your comment or question.
I greatly appreciate it. I had three questions or areas. The first is I've noticed that there's been a great deal of travel and speaking engagements with the State Bar regarding the work of this committee. And from reviewing the materials and attending one, there's a particular point of view that I can say it does not represent the points of view that I've provided or that the legislature has provided related to the work of this group. It seemed to be, in my opinion, very one-sided. I had questions about that. And secondly, about the expenditure of public funds, both with the entire amount that's been expended for this committee, as well as for those travel and speaking engagements, whether there's accounting for those public funds that have been expended. And then thirdly, I'll just note, I just got out of a 7-week jury trial, so I recognize that my schedule has been more impacted and perhaps I haven't been as immediately available as I would have liked, but I did note we got materials as late as yesterday. And I would just say personally, given that I literally got out of a trial this week, that it's very difficult to have meaningful feedback when you're given less than 24 hours to review materials and to provide substantive feedback. And that if we want substantive feedback from our members about the bar rather than what appears to be perhaps predetermined decisions, that we need more than 24 hours. And I appreciate any response. Thank you.
Wendy, I want to jump in and respond to your third point because I also care a lot to make sure that we get materials out to people promptly. The materials that came out yesterday were only supplemental and responsive to materials that were posted, I think it was last Friday or possibly even Thursday, when most of the materials were posted. So most of the materials were available a full week in advance. There was one memo that we'll talk about at the end of today's meeting that wasn't posted until early this week. I don't remember exactly which day, but most of the things were posted a week in advance. You'll remember from early on, or maybe actually you weren't in on all this because it was something we talked about at the very beginning of our existence as a group. The process is that when the materials are disseminated, members of the group are encouraged to provide written response to the materials so that we will know in advance about about responses that people felt strongly enough that they wanted to put in writing. But it's sort of a preface about the contributions we understand they want to make at the meeting. So for example, what came out yesterday were some brief comments from one of our members about her reaction to the meetings, to the materials that were sent out last Friday. And then another brief response from a second one of our members as to just one of those issues. So we would not give you substantive materials for the first time the day before the meeting, except in the context of, oh, and here are the comments that you collectively have made about the materials that were sent out in advance on schedule. So you're right that we need to give people more time. We've endeavored to do that, and I think successfully for this meeting. I acknowledge that there are some past meetings where I was frustrated and let the State Bar staff know I was frustrated that I didn't think we had met the standard. But on this meeting, I think we did meet the standard. And if you didn't get a chance to read the things that were just distributed yesterday, that's okay. You will see and hear about them during the course of the meeting if the meeting indeed goes forward as planned. As for your first couple of questions or points, I don't know if anybody from State Bar staff wants to address those.
Yeah, you can, I don't have budget information with me right now, so we can ask about that. But if you wanted to, I think it's probably more appropriate to send it as a Public Records Act request. And if you could give us the specific conferences you're asking about, we can provide that information.
Thank you. I'll do so. I appreciate it.
Mm-hmm.
Patricia.
Hi, so my question is, at this moment, are we just asking questions and then we're going to vote on whether or not we want to continue the meeting for today?
Not quite.
Okay.
At this point, we're asking questions where people had issues they wanted State Bar staff to flesh out just as part of the report.
Okay.
Then when that's done, we're going to go to Brady on the question of when and whether we can entertain the motion that wasn't yet on the agenda.
Okay.
And then and I was going to do my report first, but I think Brady looks like he's back and ready, so we may as well hear from him as soon as we're finished with what is this called? The staff report that Bridget has been giving. Wendy, your hand is still raised. You have more questions for Bridget, or is that vestigial?
Sorry.
So Patricia, okay, so we'll finish with Patricia and then we'll come back to Wendy if her hand is still raised at that point.
Before or after Brady gives us an update, I would like to make a comment, but I can wait because it's more related to that voting process.
To the motion to adjourn?
Yeah,
okay, then we'll hold off on that for now. Thank you, Patricia. And remind me that you're first in line to address that issue. Seeing no more hands directed at Bridget on the staff report, I will move. I guess, Bridget, that was the first item on your staff report. Did you have other items on your staff report?
I just wanted to highlight for everyone that we had put in the materials a recent opinion from out of New York, the Upsolve case. And I don't think I need to go into detail about it now. I just wanted you to know that it came out because it's relevant to some of the things that we've been discussing. And we did hear from Rohan Pavluri, the founder of the Absolve program. And just the highlight is the challenge, Absolve is actually challenging the, on First Amendment grounds, whether the state of New York could limit speech of non-lawyers to help people fill out forms about debt collection. There was a very specific form, and it was a very narrow case, but ultimately the court found that they at least enjoined there was enough for a preliminary injunction on the state of New York from enforcing the unauthorized practice of law statutes there on First Amendment grounds, saying that it was an inhibition of free speech to prohibit a pastor who was one of the named plaintiffs in the case from helping people fill out forms related to debt collection. So we could give you a more detailed analysis, but I just wanted you to know that that was in there because it's an interesting outcome and relevant to some of the discussions that we've been having. And that's really all I have, Justice Super, as far as a staff report.
Okay, thank you. Then, having concluded the staff report, we will turn to Brady to advise us on what we can do with the motion, whether we can consider the motion.
Sure. So the answer is yes. It's not new matter. It's more a procedural motion on how we should deal with the actual agendized matters. And in this case, the motion's to adjourn the meeting and not deal with them today. So given that there's been a motion and a second, I think in accordance with our sort of condensed Robert's rules, we've initiated it. It would be appropriate to have a discussion of the motion and then a vote.
Okay, great. So we will move to that now, and then if the motion is defeated, then I will give my comments or whatever would have been next on the agenda, and then we'll get to new business or agenda specific business if the meeting goes forward. But the motion is that we adjourn this meeting immediately, and it was seconded. And so in opening discussion, I would like to call on Patricia Scutiero.
So what I'd like to say is that it seems like it's an uphill battle for people to try to facilitate access to justice. And for me, like, I feel like psychologically, just canceling the meeting for today is just a little bit of defeatism. In my personal opinion, obviously everybody has a chance to vote on this. But I would like to just read something that I recently heard from Governor Newsom, who actually is leveraging TikTok to reach the community. And so it's a piece of it. It's not the whole thing, but he says, he's talking about a certain group, and he says, nothing more than just bullies. They are about power. They are about control. They're about the zest for demonizing and other vulnerable communities. And in the great irony is they're taking away your freedom to make choices. Now, I think that this system is a freedom to make a choice. And I'm kind of concerned with the fact that there isn't enough good PR. Yeah, I agree. Maybe we need to leverage different technology, but I don't think that we should cancel this meeting and give up because of a bunch of bullies trying to keep us from the mission, which is to help empower other people. So I ask that we please continue the meeting for today and don't let them push us down. Thank you.
Okay, thank you, Patricia. Is there other discussion of the motion? Micah.
I actually have a question, and I don't know who the appropriate person would be to answer this, but my understanding was that the Board of Trustees agreed to pause the work of this committee. And I'd like to know what kind of procedural process played out to unpause the work of this committee and when that decision was made.
Micah, I'm not clear on what you're referencing. Did the State Bar Board make a formal public decision of some sort that I'm just not aware of?
Well, I think the president said it in a letter to the legislature that the organization, the state bar, was going to pause the work of this committee, and it has been unpaused.
Are you talking about the letter several months ago in
Yes.
response to the events in maybe December?
Correct.
Okay, so now I didn't understand that that's what you were referring to. I thought you meant something recently that the bar board had done. So can you restate your question and I'll try to respond to it?
Sure. Was there a formal process that was followed, either the leadership of this committee or the Board of Trustees, where a decision was made to to commence working on the Sandbox committee again?
Well, maybe the state bar staff has something they want to add, but yeah, I'll see if state bar staff has something they want to say in response to that.
Sure. I honestly don't remember, Micah, if the board, I don't believe the board ever officially voted to stop the committee. But when we got the letter back in December, with at least discussions with the leadership of the Board of Trustees and leadership of the bar, decided that was the best thing to do to pause. They did pause. And then I'm trying to remember exactly the chronology of events, but if you remember at the March board meeting, if you remember, we kind of went through this in June. There was a revision of the charter, and the Board of Trustees revised the charter based on the feedback that they had, and we heard from stakeholders or discussions that happened in the interim between December and the March meeting, to revise the charter to address some of the concerns. There were, the composition of the working group was changed. If you remember, it was narrowed. There were specific things that the Board of Trustees was asking the working group to address. They voted to adopt that. And then we had new members of the working group join us. And so the Board of Trustees has been aware this whole time, and with the readoption of the charter, that we would go forward as we have. So they have been in the loop. I don't think they ever formally voted to stop anything, but certainly with the readoption of the new charter, they were telling the working group to go forward with the revised charter.
And was there any conversation after amendments were made by the legislature to the dues bill? So we had a meeting in June, and I understand what you're saying, and that's probably why we had that meeting in June. But then the legislature, and I don't know if they're the bullies or not, but they seems like they take very seriously their duties and obligations, and they amended the dues bill. So was there any conversation or discussion about whether or not this meeting should go forward, and for us to continue to do this work or not?
So Micah, I thought I had responded to that, but if I didn't, let me do so now. I checked in with the bar staff and confirmed that there's no legislation yet where the legislature has decided to adopt the amendments to the bar bill. The Senate Judiciary Committee voted for them, but the Senate itself hasn't voted for them. The legislature hasn't voted for them, and the governor hasn't signed them. So they're not the law. They might well be soon, and we absolutely will react when we're further along. But where we are right now is there's been something adopted. There have been amendments adopted in the Senate Judiciary Committee, and that's just a very preliminary point. And so in the legislative process, and because it's a preliminary point, I didn't think that it should stop this meeting from going forward. And so to the extent that I played a role in making that decision, that's why I made that decision. And apparently the state bar staff had a similar view, because the state bar staff also was prepared for the meeting to go forward.
Okay, so my question may have been worded a little confusingly. So let me, all I'm trying to do is confirm whether or not there were conversations between people about whether we should go forward with this meeting or not. And it sounds like there was.
Well, I certainly talked to someone at State Bar staff about the fact that this amendment had been proposed and what were we gonna, that the amendment had been adopted at the Judiciary Committee, and what did that mean for our efforts? And this is actually something I was going to get to after we considered your motion, but since you raised it.
It wasn't my motion, but go ahead.
Oh, I'm sorry, after the motion. But let me jump to it ahead. You'll know that one of the memos that we are going to be discussing if the meeting goes forward is what role should a California licensed attorney play in a sandbox entity. And there were two proposals that we had previously discussed and in a prior version of the memo. And we added a third option to be discussed that was added precisely as a result of the fact that the State Bar Board said to the legislature, we hope as you continue to discuss this subject, you will consider amending the language to require any sandbox entity to be majority owned by attorneys. So it seemed important, given that the State Bar Board was thinking that that might be a better thing for the legislature to adopt than what the legislature was currently considering, that be one of the options we consider. But we as a committee are being asked for our views. So we are not bound by what the State Bar Board sent to the legislature. We're not bound by what the Senate Judiciary Committee passed. We're being asked our views. And to the extent we have a view today, I hope we'll get a chance to discuss and figure out if we have a view, and if so, to articulate what that view is and why, and to adopt it. I don't presume to know whether any of those three options or some other option will emerge as the view of this group, a majority of this group. But my hope is that we will get there and have that discussion so that if we continue, we can build on that block. If we don't continue, obviously, it won't be so important what this group has decided. But the way that I thought it was appropriate to account for what's been going on in the legislature was to give you all full information, which the bar already had by the time I'd gotten back from vacation, and to keep in mind those discussions as we go forward with our work, but not to stop our work unless and until the legislature as a whole has spoken, not just the Senate Judiciary Committee.
Okay, so Kevin has his hand up. All I'll say in closing is that I would urge folks to vote in favor of this motion. It's, to my mind, quite arrogant to ignore the clear guidance that we have gotten from the legislature and to continue to do this work with the language that's pending now and its anticipated adoption.
Can you just explain what you mean by with the language that's pending now? Oh, you mean that's pending now before the Senate?
Correct. And
got it. Okay, thank you.
And will be pending in the Assembly.
Right. I just wanted to make sure I understood what you meant.
Right. So now it goes back to its house of origin. It goes back to the Assembly with that language.
If it passes the Senate on the floor, which it hasn't yet, because unless something happened this morning that I don't know about. But I'm sure you all will keep us posted. Kevin, you're up next.
Okay, I would just like to be reminded, what is our timetable for this working group to finalize a report?
So
and it's not just the idea that we have to have a report that's going to be subject to public comment that will come back. So I just need a reminder. I mean, what are our deadlines? Because that has something to do with my decision whether we should have this meeting, notwithstanding the legislative language that we've seen in the AB 2958.
Well, that is certainly part of why I thought it was helpful to go forward with this meeting. We've been told we have till May. I don't remember if it's the last day in May or some earlier day, but it's a day in May is our deadline for the report. with the understanding that once we give a report, that's to the State Bar Board, they put it out to public comment. So we would then perhaps convene later after public comment to address public comments. But the deadline for the report that we're supposed to give the State Bar Board on what our recommendations are is in May. Patricia, your hand is raised.
Could I just
I'm
follow
sorry.
up on something?
Yes.
My only concern is that what we vote on, I'm a little bit concerned because so much of what we have is still relatively incomplete that's been presented to us to vote on. And I would hate us to send a message to people that, well, we don't really understand what they've voted on so far. So that's one of my concerns. One of my concerns is the short amount of time we have as a working group to try to put out a report that makes viable recommendations for going forward. On the other hand, I'm afraid to have votes before the legislature votes that is going to signal to them and leave them in a quandary. I mean, this is a fairly incomplete. They're really not there yet. So I'm still kind of on the fence as to which direction we should go in. But I hope to have, I will vote one way or another. I won't abstain. Let's put it that way.
I will point out one other thing, which is that if the meeting goes forward and there's a particular agenda item on the agenda that people don't think we're ready to vote on, you could either say, we don't want to vote on this, or you could vote no, not because you were substantively against something, but because you didn't want to make a decision on it today. So if the meeting goes forward, that doesn't mean we have to make decisions on everything that's before us. It just means that we will have discussions and consider making decisions on each of the items on the agenda.
Okay, thank you.
Patricia.
We sometimes in these meetings, we use strong language, like, implying that it would be arrogant of us to go forward. I feel like it's not something like throwing out these strong words in these meetings is inappropriate. It's not arrogant. I don't believe that it's arrogant for me as a non-lawyer or other people who are non-lawyers and consumerists who actually need the services. And the bottom line is they work for their money and these are their needs. So I feel like, yes, we do need more representation from the non-lawyer population, because sometimes these meetings become more of a higher level ego-driven conversation. And today I'm so frustrated because if this is our last meeting, I feel like I need to voice that opinion. And we're here to help the public and we're not here as an ego trip. And I feel uncomfortable in some of these meetings where it becomes strong language like arrogance. The entire committee is not arrogant if they vote in one way or another. That's trying to sway an opinion, and I don't think that's appropriate either. So that's my 2 cents there. Okay. And I apologize, but I have to say it and on record. Thank you.
So thank you, Patricia, and no apologies necessary. But I do want to offer a little comment in response to your comment, and it's a plea to every single member of this committee to be forgiving of each other, because just as arrogant could be viewed as an inappropriate word, I think bullies or ego-driven could be also. And I want to make sure that each of us gives every other member of this committee the benefit of the doubt and realizes we are all volunteers on the committee. We are all giving our own time because we care about this issue. And while we sometimes state our views strongly, and I do that as much as others do, I acknowledge, we need to try to stay engaged on the merits and cut each other a little bit of slack when we think somebody else has gone too far in their tone. So thank you all for your strongly worded and strongly held comments, because I think they all add to the debate. Marta.
Thank you. One of my grave concerns about going forward with this meeting today is that we learned, and it was confirmed, what we probably already knew, is that the state bar is in further negotiations with the legislature on the very on this committee's very existence, whether or not it will be this group as constituted will continue its work, because that is what is the focus of the legislature, and obviously the state bar has taken a completely opposite view. One of my concerns about going forward today and addressing the very meaty issues that are on today's agenda is that our work is going to be then used to go back to the legislature and say, see, this is what they're still working. They want to continue to do this work. They're voting, we're handling these issues. And in other words, the work that we're doing today becomes a pawn or a bargaining chip in those continued negotiations. And I think that essentially cheapens the work that we're trying to get done and because we are affecting, we are making decisions that are very, very important to this state and to legal services being delivered by people other than what traditionally have been delivered for hundreds and hundreds of years within this state. And so that is my real grave concern, is that we are being used, frankly, for going forward today. And that's going to be taken back to the legislature to say, look, they're still working and they want to continue this work. I'd rather have the legislature work out what they're going to be doing and have it on those terms, not on something that we're doing here today. Thank you.
All right, thank you. Justice Zeland. You're on mute.
Sorry about that. What I wanted to say is very similar to what Marta just said, but I have a question following up on what Marta has said, is whether and maybe this is for Bridget, but whether the people who are discussing it with the legislature have any view as to whether our continuing to work or any resolution we may reach today would impede their negotiations with the legislature to allow us to continue our work. Because if it would in fact impede it, and we have reason to believe that, that's a concern. If the legislature is operating on a different plane and really doesn't look at what we're doing on a monthly basis, then I would feel differently about it.
I really don't think I have an answer for that, Justice Zeland. I mean, I don't know how to anticipate what may or may not ultimately influence what the legislature wants to do. I do think they are paying attention to what we're doing. But I don't know if it's, I don't think I have a good answer for you, unfortunately, about what what will influence one way or the other, how the amendments end up happening if they do.
Thank you.
I do think it's safe to say that the bar board knows this meeting is going forward. I, for example, spoke last week with our 2 ex officio members just to sort of talk to them about what we were up to. So the bar board knows we're going forward, and they haven't suggested that we shouldn't. So I think Bridget's comment is we don't know what the legislature is thinking, but we do know that the bar board isn't asking us not to go forward. That's the only thing I can offer by way of supplemental response to that. Is there other debate on the motion before us, or are we ready to take a vote? Seeing no hands, I would ask Mimi Lee to call the roll, take the vote, please.
Okay, Mary Baldwin.
Can you restate what the resolution is that we're voting on?
The motion is to conclude the meeting.
No.
Becky Sandifer,
No.
Marta Alkenbrock,
Yes.
Andrea Ruda, Wendy Chang, David Engstrom,
No.
Dan Grunfeld, Eric Helland,
No.
Kathy Huang, Micah Star Liberty,
Yes.
Kevin Moore,
No.
Wendy Mussel. I think we lost Wendy.
Please,
Lucy Reed-
please come back to Wendy at the end of the roll call.
Okay, I will.
No.
Oh,
Okay.
thank you.
Thank you, Lucy. Toby Rothschild.
Yes. I mean, no, I'm sorry, voted no.
Okay.
Sorry.
It's okay. Patricia Scutiero,
No.
Sacha Steinberger, Betty Williams,
Yes.
Lori Zelon.
No.
Okay. I don't see Wendy here. But I do see Kathy. Kathy, did you vote? So if you did, I did not hear you. Okay, I don't think she's connected by voice. Okay, so the motion fails.
What was the vote, please?
3, 5, 6, 7, 8, 9, 390.
That is to say 9 votes against
Okay,
stopping, 3 votes in favor of stopping, and no abstentions.
correct.
Okay, then we will continue, and I will offer just a couple of comments, what's left that I haven't already given of my, comments from the chair before we get into business. I wanted to highlight the importance of the Upsolve decision that circulated. It's just a district court. We don't know whether it will be affirmed on appeal, and it's in New York, so it has no direct influence on what we do in California. But if a binding court in California were going to analyze the issues the same way that the federal court in New York analyzed the issues in considering the First Amendment challenge to Upsolve, then they would say that the state of California cannot enforce its UPL laws, its laws against the practice of law by non-lawyers, against entities against Upsolve, if Upsolve were to bring that case. So it essentially puts the court in place of what we have been proposing a Sandbox entity would do. It puts the court in place of deciding whether there are entities that don't fit within the normal practice of law definition that should nonetheless be allowed to proceed with their business model under protection of the First Amendment and without any of the regulatory measures that we will be considering later today. So I think, even though that's just one little decision that isn't binding on our courts, it is an interesting comment from the courts about the importance of what we're doing and the risk that if we don't do what we're doing, that the courts may end up doing it for us in a different way. So that's why, if you haven't had a chance to look at the Upsolve decision, I want you to think about giving it a look. Besides the fact that we heard from the presenter and know a little bit about that business model as a result of that presentation several months back. The other thing I want to talk about is how some of the decisions that will come before us in today's agenda, if we consider all the items, are different from the past. We have so far proceeded by making resolutions and either adopting them or editing them, defeating them, whatever. But today, for the first time, we are going to consider 2 different portions of a chapter draft. And the reason that we are proceeding to portions of a chapter draft is that because we do have this May deadline, I want everybody to be thinking about, well, what are we working toward? What is this report going to look like if the committee keeps going and does in fact have a report we need to turn in by May? And so where we had already made enough decisions that it seemed we were ready to write a portion of a chapter draft, we generate, and by we, State Bar staff and members of the leadership team, generated some chapters that embody decisions that we have already made, with some minor amendments that we'll discuss as we go along. And so the thing you're being asked to vote on when we get to those two chapter drafts is whether what's here so far embodies what you want our final report to look like in this part. And it's a preliminary vote because we could still make changes to it later. But what it does is it puts a stake in the sand and says, unless we vote on changes later, this is what we want our report to look like substantively. You know, the authors of the draft wouldn't make anything more than, you know, minor editorial fixes and whatnot before presenting you with a report at the end that would be all the little pieces we'd been voting along the way. It may seem funny to talk about something that's focused on finishing our report in May at a time when, as we've all just been discussing, whether or not we get to May is highly contingent. But on the theory that we are still tasked with the job, that's sort of a piece of the job that I thought we were ready to consider and to vote on today. So the first two agenda items, as I say, are these partial chapters. Then we will get to unsettled issues where we didn't have a resolution yet. So for example, when we get to what role should a California licensed attorney play, you all have seen a memo before, or at least those of you on the scope committee have. There's been extensive discussion of the issue before, but we never got to a place that the committee as a whole voted. So we are now at a place where I wanted us to be able to have a vote on that if we're ready to have a vote on that issue when we get to it. And likewise, although it's at a somewhat earlier stage, consideration of what standard of care, if any, should we recommend that the legislature specify for entrance in the sandbox, that what they owe consumers as a standard of care for civil tort liability. So that's the agenda we have to look forward to. We have already been in session for a full hour. So I want to give everybody just a 5-minute stretch before we start with our first agenda item.
Before we do that, can we just take a vote on the action summary, please?
Oh, yes, that seems like a quick enough item. We could do that first. There's an action summary from our last meeting that was circulated with the materials last week. I hope you've had a chance to review it. If there is a motion that we adopted as an accurate summary of the work we did last month, I would entertain that motion at this time.
So moved.
Eric Helland has moved. Does the motion have a second?
Second.
Thank you,
Kevin
Kevin.
Moore has seconded. Is there any discussion, any corrections anyone wants to offer? Are we required to call through the vote, or can we do this? Okay, then Mimi, please call through the vote and see.
Okay, Mary Baldwin,
Yes.
Becky Sandifer,
Yes.
Marta Alkenbrock,
Yes.
Andrew Ruda, Wendy Chang, David Engstrom,
Yes.
Dan Grunfeld, Eric Helland,
Yes.
Kathy Huang, Micah Star Liberty,
Yes.
Kevin Moore,
Yes.
Wendy Mussel,
No.
Lucy Rica,
Yes.
Toby Rothschild,
Yes.
Patricia Scuthiero,
Yes.
Sacha Steinberger, Betty Williams,
Yes.
Lori Zelon.
Yes.
Thank you. Motion carries.
Okay, now we'll have a 4-minute break. We'll come back at 10 minutes after 11 and start in on agenda item number 1. Thanks, everybody. See you in a few. Before we move to agenda item 1, I just want to make sure that the record accurately captures the vote that Wendy Mussel registered in the chat, that she voted not to proceed with the meeting and was only prevented from saying so by technical difficulties. So Mimi, can you confirm you got that?
Yep, I got it.
Good. All right. So new business action item number 1, discussion and possible action on recommendations for structure and governance chapter. I would like to call on Mary to present this topic, please.
Sure. So as you see from the memo that we distributed for this item 2A, we've this goes to Justice Tucker's point about how this meeting is looking at some differently kind of formulated resolutions, which is that this is basically a short memo that for the most part contains a proposed chapter of our final report, which consists of primarily items that we've already approved as part of the working group, which we then reapproved at our meeting in June. And then with the exception of one additional item, which we have not discussed yet. So I want to call that out. And if you look at the memo, that's reflected in that recommendation number 17, which is on the first page of the memo. And it refers to the transparency provisions that are contained in the memo at page 2. I should say the proposed report at page 2. So we had not previously considered transparency requirements, although we've talked about them and referred to them from time to time. So in terms of proceeding, recognizing that most of this is content that we've discussed many times and have approved now twice, I would propose that we focus on these transparency provisions, which we have not previously considered. If someone wants to make the recommendation that's reflected as recommendation 17, and then we can discuss it, that's fine, open to proceeding, but we certainly want people's views. So the transparency provisions as reflected in the draft report here include that the Sandbox regulator be subject to the government transparency statutes, including the Bagley-Keene Open Meeting Act and the California Public Records Act, just as members of the organization of the State Bar and other government affairs offices are. And then and this is something we have discussed from time to time, that the regulator adopts a conflict of interest policy for the board members to ensure independence of the board's decision-making. So those are the two kind of components of the transparency policy that is contained in this draft report. So again, I would suggest we discuss those first, and then we can look to this as a proposed chapter of a written report.
So Mary, are you making a motion that we adopt recommendation 17, or are you simply saying you'd like someone else to make that motion before we go?
I can make that motion, sure. I move or I propose recommendation 17 as reflected in this memo, that the working group recommends that the Sandbox regulator be subject to California's government transparency statutes, including the Bagley-Keene Open Meeting Act and the California Public Records Act. Additionally, the Sandbox regulator should establish a conflict of interest policy for its board members to ensure the independence of the board's decision-making.
Okay.
Happy to second.
Motion made by Mary and seconded by Eric. Is there discussion of this particular motion? Kevin?
Yeah, can I make an amendment to replace the word should with the word must with respect to a conflict of interest policy?
So then the sentence you're amending would read, can you, additionally, the Sandbox regulator must establish a conflict of interest policy for its board members, et cetera?
Yes.
All right, so the question to Mary is, do you accept, and then to Eric, do you accept that as a friendly amendment?
Kevin, how about the word shall?
They both mean the same to me.
All right, so Mary is changing the word should to shall in her motion. Is that acceptable to Eric as the seconder? I'm not hearing.
Sorry, having trouble finding my button. Yes, that's acceptable to me.
Okay. Further discussion. Looks like Bridget has her hand raised.
I think, Micah, do you still, I thought Mike had her hand up for me, but maybe she put it down.
I don't see it as up, but
okay.
I'm happy to.
That's fine. I was just going to say, as a drafter of this, as I've been working on kind of drafting the report, the language, with respect to the should or shall, it's that we're making recommendations. And so it was, I wrote the word should in here just to be intentional, because these are all recommendations as opposed to like actual rules. And so that's why I put that language in the way it is, for what it's worth to you all as you're thinking about this motion.
Okay. Mary is in charge of what the motion actually looks like. So if she wants to make further changes, she can, but are there further discussion of the transparency motion? Marta. Marta, you're on mute.
Pardon me. What is the conflict of interest policy?
Well, I
it's not
think sorry, go ahead.
Well, it's not a specific one. If you see on page 2, the regulator should establish one, but we don't specify at this point what that conflict of interest policy should be. We can do that later if it was appropriate, or we can leave it up to the regulator. We've had discussion, in our meetings about looking at the conflict of interest policy that's in place, for example, for the State Bar Board and other agencies. And we could, at some point recommend something more specific than that, but it's not spelled out at this point.
I mean, I'm in favor, obviously, of a conflict of interest policy. I would think that it would be important that we provide at least guidance if with respect to what that conflict of interest policy should be. I mean, I would like, if we could, if I don't know if it's a friendly amendment or not, but I think we need to have some type of statement or guidance or instructions about the shall language that has now been, as part of the friendly amendment, what that conflict of interest policy should be.
So I guess my question to you, Marta, is, are you proposing something specific, or are you just putting a peg in the sand that as we go forward, this is an area you would like to see and perhaps to contribute to some further work?
Well, I think that's further work for us to do if it's not being proposed here today, which it doesn't appear that it is, but I think we have to set forth a conflict of interest policy.
Okay.
That is what has to be done.
Would you like to work on that? If this task force goes forward?
Sure.
Okay. So staff better be keeping track of that, and we will come back to that in due course. Other comments about this particular motion? Hearing none, I believe, Mimi, we're ready to call for a vote on recommendation 17.
Okay, so just to reiterate, the motion is to.
I'm sorry.
It's okay.
I mean, can I just take a half step back then? If with my comment of a conflict of interest policy, can we say to be determined by this working group? Can that be a friendly amendment that I include, or is that appropriate in this resolution? I think we should, based upon my comments and based upon Justice Tucker's comments, I think it needs to be included here.
So I'm going to put the question to Mary because she gets to decide what's a friendly amendment and what isn't. I think regardless of whether or not we add anything to this, we can have it on the agenda for work that you and perhaps others will undertake in the future. But if you're asking that a specific change be made to this language before it be adopted, let us know what that is, and then Mary will tell us whether or not she accepts that as a friendly amendment or does not. And while you're getting ready on that, Marta, I'm going to give you just a moment to get ready on that, and I'm going to call on Kevin in the meantime, and then we'll come right back to you.
Since this is a resolution, rather than being overly specific, but give some idea of where we're coming from, could we say something, say after the words, it shall establish a conflict of interest policy, e.g. analogous to the policy that governs the State Bar of California's Board of Trustees, comma, for its board members to ensure the independence of the board's decision-making. In other words, just give an example, because I think what we need to do on anything we vote today is to send the message that the resolutions that we're making are all about public protection. And I think we understand that the conflict of interest policy that is governs the Board of Trustees of the State Bar is intended to protect the public, at least in part.
Okay, so now Mary has two potential friendly amendments to react to.
Could we see Kevin's written out there?
Yeah, hold on one second. Think it, something along those lines. Did I capture that accurately?
Yes.
All right, and then let's go back to Marta and let Marta spell some language out so that we can capture that, because I went back to Mary prematurely.
That's fine. I appreciate Kevin's wording. Thank you, Kevin.
Okay.
I think that's the proposed change is fine.
Okay. May I ask to enlighten our discussion whether anyone can tell us what the policy that governs the Board of Trustees of the State Bar of California is on conflict of interest?
Sure, and I mean the very basics are set forth, and then there's elaboration in regulations in Business and Professions Code section 6036. So that is required recusal if a decision of the board would, I'm not precisely quoting, but would be reasonably likely to have a material impact, and materiality is assumed on any financial interest, which is defined as theirs or a member of their households, sources of income in the last year of greater than $500, investments of over $2,000, basically borrowing from the Political Reform Act. And then there is a standard for personal non-financial conflicts, and they must recuse themselves if they have a personal non-financial conflict that would preclude them from basically impartially addressing any board decision. And while that's phrased as a subjective standard, we advise them very cautiously to avoid any appearances of conflict in recusing themselves.
Brady, thank you for giving us that great, thorough answer in response to it. A question you weren't expecting. I think that helps us make a more informed vote, which we'll come to shortly. I will point out it says e.g. and analogous, so we're not actually being asked to vote on whether to adopt the same rules exactly. We're just pointing in this language to the rules that Brady just went over as the kind of thing we have in mind for conflict of interest policy. Wendy. Wendy, I can't hear you very clearly. Can you just start again?
Sure, and I can do it in the comments if you can't hear me. Given the importance of these issues, I consider these central to a functioning regulatory agency. It seems to me that we should have a draft of what those exact policies look like before we have a vote on this. Because it seems to me that the entire success of the endeavor will rise or fall on some of these issues.
Okay, I think I heard the entirety of your comment, although it faded out perhaps at the end or cut off a little funny. Can you still hear me, Wendy?
Yes, I can.
Okay, good. What I heard you say was you don't want to have a vote on this until we have a policy in hand. I hear that. The motion is before us, so at least at this point, I'm going to take that as an explanation for why you'd like us to vote no on this policy at this time. Would that be a fair way of characterizing your comments, do you think? Wendy's on mute, but that was a question for Wendy if she's able to answer.
She answered yes, your question in the chat.
Oh, thank you. Thank you very much. Okay, perfect. Kevin.
I'm going to offer my position on this, where I'm willing to vote where we don't have a specific policy to vote on. Because I think if we're going to send out anything from this meeting where we approve anything, you can kind of throw this away, but I think this is adding further protection to the public in terms of governance or regulating the decisions that are to be made by whatever regulatory authority is eventually voted on, that they are constrained by the same, I guess, constraints as are the members of the Board of Trustees of the State Bar of California, which doesn't seem to upset anybody in terms of the protections that are made available to the public. So I think by adding this, we're sending a message. We're looking at this, we're tightening up the recommendations that we had before with regard to the governance issues by adding this conflicts of interest and also the transparency requirements. I think that's important for us to do.
Okay, thank you. I'm going to call on Marta in a moment, but just want to let everybody know that if you want to work with Marta on a conflicts policy, please let the State Bar staff know, because we could have a group of people who work on that project together if we continue. Marta.
I agree with Kevin that these are important aspects of the regulator, transparency, and a conflict of interest policy. My concern is that we should spell out in voting on this resolution what exactly the conflict of interest policy is. And if we want it to be that the policy is the same as what governs the Board of Trustees for the State Bar of California, then we should say that in this resolution. And I think with that in mind, if Brady wants to give us that language, we can footnote it in this resolution and then we can move forward with a vote. But I think it's important that it's stated in the resolution in and of itself. I'm a little concerned that the analogous language, without spelling out exactly, I mean, it's there that we certainly want a policy, but I think it'd be more clear if we actually had it stated in the resolution.
So Marta, I have some concerns about asking this group to make an informed vote based on just having, I heard Brady say something about regulations, and it sounds like the policy that the State Bar Board has is not something one reads and understands in 5 minutes. So I'm concerned about asking this group to vote based on something they've never seen before, to adopt exactly the same policy, and would encourage you, certainly if you want to make a further request for a friendly amendment to Mary, you should do that. But I would encourage you to think about, as an alternative, not asking for an amendment to this language, but instead sitting down with anyone who will help you to be the policy, the people who generate the memo that says this is the State Bar policy and we think it should be adopted, or we think it should be adopted with these tweaks, which is something we could pursue as soon as the next meeting if this effort goes forward.
Well, I appreciate that. My concern is that if this group is disbanded, which it may be, that if someone takes up this paper at some point in time, or if the next, or whatever happens, the policy, the conflict of interest policy isn't set forth in this resolution in a full-throated discussion, and that we're not given that opportunity to look at this State Board of Trustees policy on this issue, nor frankly any, or examine any others. That's the concern. And so I don't know, since we can't see into the future whether or not this group is going to be, even has a future, I don't like putting out something that isn't full-throated with respect to a statement as to the conflict of interest policy that we want the regulator to adopt.
Okay, then just for sort of procedural, I'm going to ask you in a moment to request a friendly amendment if you want to the language that's here. But in the meantime, I have both Mary and Lori with points they want to make.
Thanks. I understand the concerns, but in my view, this is just a recommendation. If we were to go ahead as a committee, any recommendations, we have ample opportunity to take a closer look, and I would welcome a close, careful look at what a suitable conflict of interest policy might be. It might be, given the nature of the sandbox and the nature of the board, for which we propose very specific criteria, et cetera. It might be that we want to have a slightly different conflict of interest policy that we think would better protect the interests of the public. So I don't want to rush into that, and I don't see why it's necessary to what we're doing when we say very clearly that the board shall establish a conflict of interest policy. We give an example of one that I don't think anybody I've never heard anyone criticize. To me, that's sufficient understanding that we will have the opportunity and to look more carefully, and if we determine that it was appropriate, to add to this recommendation a more detailed policy, and I certainly support us doing so.
Okay, thank you. Justice Zeland.
I was going to suggest a slightly different approach, which is a conditional approval of this recommendation, subject to the committee's review of a specific proposed policy, so that we get, I think we are in agreement on the basic concept, but with varying degrees of comfort as to the language of a policy. And a conditional approval would put a marker in so that we know we have to come back to it and give us time to consider what that policy would be.
Okay, I'm going to ask you in a moment to figure out how to frame that as a request for a friendly amendment, and then I'm going to ask Mary whether or not she accepts it as a friendly amendment. In the meantime, Micah, you're on, and I apologize for not having noticed earlier. Your hand doesn't show against the color of your background as easily as some people's do.
It may have been a late raised hand. Why is there any reason why we need to take this specific resolution up today? If we meet in the future, we would have the opportunity to review the state bar's policy on conflicts of interest, maybe take a look at other regulatory agencies' conflict of interest policies, and be able to make a better informed decision. So maybe that's a third approach, is table this entire resolution until we have the opportunity to take a look at stuff. I mean, I'm sure the state bar could get us their policy, and we could look at it over lunch, for example, if we wanted to, but it might not be enough time to digest and come up with tweaks or ideas. But this is so important to any work that any quasi-governmental entity would be doing, in particular for this sandbox group, because there are serious concerns about conflicts.
Okay, so Micah, I'm going to ask you, as I've asked the others, to be specific about what your requested friendly amendment is, and see if Mary will accept it. Which I'll circle back to Justice Zeland. Do you want to, or Mary, if you feel like you have a good enough view of what these various friendly amendments are without having them being reduced to words, if you want to react to whether you'll accept any or all.
I understand everyone's concerns. I think we're all on the same page around the importance of the conflict of interest policy. I don't in any way see voting on the current resolution as precluding or negatively impacting or even shaping the work that would come down the road to put together a proposed policy. So my preference would be just to vote on the resolution as drafted. Of course, if anyone wants to propose specific additional language, but I don't think any of us disagree. And this seems so, to me, uncontrovertible and important that I would like us to vote on the resolution as currently drafted.
And when you say as currently drafted, you mean including the amendments that are shown on
Yes,
the
the
screen,
amendments
right?
that we've already approved and are sitting on the page right there.
I think that is an answer to the proposed friendly amendments. No, thank you. Is there other discussion? And I think Kevin and then Micah have comments.
Okay, I just wanted to note that what we've come out with so far in terms of our description of the board, if you look at page 1 of attachment 1, which talks about paragraph B, talks to, or I should say speaks to, the governing board structure, composition, and policies. All that we've actually have presented so far is the structure and composition. And I'd like to have something about policies. And I think that's what this resolution adds. And I think we should go forward with the vote today.
Thank you, Micah.
Yeah, I just want to clarify that I wasn't suggesting a friendly amendment or an amendment at all. I think technically under Robert's rules, what I'm suggesting is a motion to table the motion asking for a vote on the language. So I know we don't follow Robert's rules, or sometimes we do. I'm still not totally clear on how the state bar does that, but I think a motion to table requires a vote on the motion to table if we're following Robert's rules. But I just wanted to be clear about what I was suggesting and what I was not suggesting.
Okay, thank you. In a moment, I'm going to ask the state bar if there's a rule that I have to follow, but unless they tell me that I have to do something and call them the table motion, I'm going to suggest that you consider voting no for reasons that you don't want us to consider this yet. In other words, if you think we shouldn't be deciding this today, vote no, even if you agree with some or most of the substance of it, and we won't construe that as you being opposed to the same issue coming back at a later time with more detail. Is the bar parliamentarian satisfied with that, or do I need to call a vote on the motion to table?
Randy, do you want to take this? I think this was addressed in your memo, and I think I'm looking at the the version that was circulated.
Actually, I wasn't going to address the parliamentary question.
Oh, sure. Well, so I will just jump in. The last September, I believe it was, when we decided to adopt a streamlined approach, the memo basically said that if there was a motion to table or to amend and a second, that would be discussed and voted on first, and then you'd return to the original motion. I think that.
So we have to vote on the motion.
I missed it.
So we have to vote on
the.
So we have to vote on a motion to table or amend before we can return?
Correct. That's
okay.
The sort of streamlined Robert's rules that we
So is there a second? Is there a second to Micah's motion to table?
I'll second.
Marta,
This is Wendy. I second.
So we sorry, Wendy, Marta beat you to it. Micah moved and Marta has seconded that we table a vote on the transparency resolution. And so I'm going to ask Mimi to call the roll where the proposal is that we just not vote on the transparency resolution.
So the motion is to table Mary's motion to adopt recommendation 17 as amended.
Exactly.
Mary Baldwin.
No.
Becky Sandifer.
No.
Marta Alkenbrock.
Yes.
Andrew Ruda. Wendy Chang. David Engstrom. Dan Grunfeld. Eric Helland.
No.
Kathy Huang,
Yes, to tabling.
Micah Star Liberty,
Yes.
Kevin Moore,
No.
Wendy Musell,
Wendy, we're not hearing a
right.
vote from you.
Yes, my vote is yes. Thank you.
Lucy Rica,
No.
Toby Rothschild, Patricia Scutiero,
No.
Sacha Steinberger, Betty Williams,
Yes.
Lori Zelon.
No.
1, 2, 3, 4, 5, 1, 2, 3, 4, 5. The motion fails 5-7.
Okay. Is there any discussion on the motion before we move to a vote on the motion then? Randy and then Wendy.
Just wanted to offer a quick observation that I think the appeal that I saw in the original motion as amended by Kevin's parenthetical is that, and Brady can correct me if I'm wrong, I might be completely off base, but I do believe that the organic law that would create a regulator and its governing body can specify certain laws governing things like conflict of interest, but completely separate and apart from what that might say would be the general law that applies to any entity that exercises legislative or quasi-legislative or other regulatory agency power. And so there might be something that we conceive of that we think is absolutely correct, but it might not be the universe of conflicts laws that apply to that entity. And I think you should keep that in mind that, you know, at some point there will be a regulator if it's created, and the law would dictate in part what might be the conflicts of interest standards applicable to that regulator.
Okay, that's a helpful comment, and I can tell we have a lot of expertise to bring to bear on coming up with a specific policy. Marta.
Would Mary accept a friendly amendment as a last sentence that to recommendation number 17 that says something like the Sandbox Working Group agrees to prepare a conflict of interest policy for the Sandbox regulator at a future date?
My only hesitation there, Marta, is that by phrasing it that way, that presumes that the working group is able to agree on a conflict of interest policy. I think I'd be more comfortable with, and I'm just not sure of that based on partly on this conversation, that will be the case. So I think I would rather say something like the Sandbox Working Group or the working group agrees to consider a proposed conflict of interest policy at a future date or something like that. And so making clear, you know, that we intend to consider and, you know, an actual specific policy to recommend, which if the working committee were to agree and vote would obviously then get added to this set of recommendations.
Okay, so Marta, I hear her partially accepting by rewriting your proposed amendment. Is that, so I guess with that, we go on to see whether there's any further discussion.
What?
And maybe Marta, you can better refine this, you know, draft language here if you.
How about the Sandbox Working Group agrees to propose, or a working group of this committee agrees to propose a conflict of interest policy.
Marta, can I jump in here?
Yeah.
I want to propose that we not go further with what the language Mary's just given, but instead that I commit to you that if this group has not disbanded by the end of August, that at the end of August, we can even say August 31, the State Bar is to appoint the working group to get going. And you'll be on that working group. You're the one person who's already volunteered. There are other people who've shown they have expertise who I hope will volunteer, but I won't make anybody. And that effective immediately, at the end of August, you all get started, and and I will commit that we will consider, your proposal as soon as you have one, which could possibly be at the September meeting if you work very fast, but otherwise it'd be a meeting as soon after that as you are ready. I'll certainly make that commitment to you for what I would propose to do to make sure that we make good on the intention to make a good faith effort to come up with a conflict of interest policy.
I appreciate that, Justice Tucker, but I would feel more comfortable if there was some type of additional language in this resolution, given that we don't know if we're actually going to have a future beyond August 31st. And so whoever or whenever, if these papers are ever picked up again, and looked at, I want to make sure that there's some type of, there will be, if you're not here and I'm not here, that these documents of some future date get picked up, I'd like to have that resolution state that the working group is going to prepare a conflict of interest policy. I mean, this is tantamount to the entire, regulatory body that's going to be examining applicants to the sandbox.
Okay, I would ask that Mimi just clean up our draft by reflecting the current state of what Mary has agreed to. We'll ask Mary if she wants to agree to anything more in a moment, but in the meantime, I'll call on Kevin.
Yeah, I think that with the elimination of consideration of general changes to the rules of professional conduct, we have become the de facto Sandbox working group, but officially we're still closing the Justice Gap working group. So let's just refer to ourselves as the working group. I mean, there's no need to add Sandbox. That's all we're working on. So just say working group in any resolution.
I think this does say working group.
It does now.
Okay.
Got it.
And I guess just on this language, I don't think that this recommendation should tell the working group that it has to propose, well, I guess propose, I don't know what that means. The working group agrees to propose a conflict of interest policy. If we're able to agree to one after the committee effort that Justice Tucker has outlined.
I think it's possible that Mimi just erased the wrong language, because I thought she had spelled out your language. It was different.
Sorry to interrupt. My notes had agrees to consider a proposed.
Mm-hmm.
That's what you originally said.
I think that's right.
To consider a proposed.
The working group, take out that first Sandbox. The working group agrees to consider a proposed conflict of interest policy for the Sandbox regulator at a future date. That's fine.
Okay, that is the proposed motion. Is there any further discussion of this motion? Marta, you have your hand raised. Is that vestigial, or you have one more comment?
It is.
Okay, then I think we're ready for Mimi to call the roll, and we'll take a vote on recommendation 17.
Okay, so the motion is to adopt recommendation 17 as amended and as it appears on the screen. Take the vote. Mary Baldwin.
Yes.
Becky Sandifer.
Yes.
Marta Alkenbrock.
No.
Andrew Arruda. Wendy Chang. David Engstrom. Dan Grunfeld.
Pardon me, this is David Engstrom. I have switched to cell phone, but I vote yes.
Awesome. Okay, thank you. Dan Grunfeld. Eric Helland.
Yes.
Kathy Huang.
Yes.
Thank you. Micah Star Liberty.
No.
Kevin Moore.
Yes.
Wendy Mussel.
My vote is no.
Lucy Rica.
Yes.
Toby Rothschild. Patricia Scutiero,
Yes.
Sacha Steinberger, Betty Williams,
Yes.
Lori Zila.
Yes.
Thank you. The motion carries 10-3-0.
Okay, thank you. So Mary, I'm going to return to you now for a discussion of the chapter more generally. And I don't know if there are comments you want to make before we ask Justice Zeland to address a comment she made in the written materials yesterday.
I'll just quickly say that, this is a draft, basically pretty faithful to what we've already approved. We did get email comments from Justice Zeland with respect to the composition of the governing board. Other than that, we didn't get any email comments from anybody yesterday. So as Justice Tucker alluded, why don't we start with Justice Zeland and explain your suggested changes to the composition of the working group, which I think specifically went to the Supreme Court's nominees.
I'm sorry, I missed most of that, but am I up?
So you're up, and the reason you're up, let's just point people to the right part of the memo, of the draft chapter. On page 2 of the draft chapter, there's a heading, right above the heading for transparency, there's a heading for governing board. And, okay, now look at the second paragraph under governing board. This governing board is proposed to consist of 7 public members. And then it goes on and it talks about who those should be and how they should be appointed. And then it says it should also be consist of 6 nominees from the Supreme Court. And then you'll see the last sentence here of the governing board. It says the Supreme Court's nominees would include at least 1 each of individuals with experience with legal ethics, the provision of legal advice and services to low or moderate income Californians, and the regulation of law-related services. And when Mary wrote this into the chapter, she was drawing on language that the working group previously discussed and adopted in a resolution. And Justice Zeland, who joined us more recently, has a suggested improvement, or at least she'd like us to consider it as a suggested improvement, that would be an amendment to this sentence I just read you at the end of the excerpt that's up on the screen. So I'd like her to explain what that is, and we'll consider it a motion and then discuss its pros and cons and whether there are further proposed changes to the language that Justice Zeland would like to have us adopt that's different. Oh, there we go. We have it written down.
Thank you, Justice Tucker. And I apologize for being late to the game, but I did come to the committee after you had done significant work, which I appreciate very much. My concern with the language about a person with experience with the provision of legal advice and services to low and moderate income Californians is that categorization could include someone who is not, does not have a breadth of experience in 2 areas. We have many valuable pro bono lawyers in California, many of whom see only a small piece of the elephant, to go to the old blind man's analogy. The reason I suggest both a federally funded legal services provider and a person with self-help experience is that our legal services providers in California have experience with a broad range of needs and a broad range of people in need that is pretty unique in the legal community. We also have, because we have self-help centers in every courthouse in California, a cadre of people who understand specifically what persons seeking to represent themselves need in the way of self-help. That has been a learning curve over the last period of years. And I think that they have important insight into what kinds of services people may need. And so I think the specificity of those two categories would be of great assistance to the Supreme Court's cadre of nominees. And that's why I propose it.
All right, so I think we could say that Justice Zeland is making a motion that we amend the language to include the language she's provided here, federally funded legal services provider and self-help lawyer, in place of that middle category in the sentence. Is there a second for that motion?
I second.
Was that Patricia?
Yes.
Okay, so Patricia Scutera seconds the motion. And then we'd like to have discussion on it. First Marta and then Mary.
First, is there a definition of a self-help lawyer? Because I saw there was a definition for the term legal advice and legal services. Is that just, I think they just need to be consistent. I understand what Justice Zeland is saying, but I just think it needs to be a little bit clearer as to what a self-help lawyer is.
So maybe tweak the language to make clear that we're talking about someone who has at some point worked in one of the court of, well, we don't have to say court affiliated, one of the self-help centers. With that, I'm going to see if Justice Zeland can help me with exact language, or if somebody else wants to propose it, but I understand your request for some additional clarification there.
And then my other question is, it looks like there's 7 public members, and it says the Senate and Assembly each nominating 1 public member. So that would be, it looks like the Senate and Assembly each nominate 1 apiece. Because
right.
Is that correct? Because now there's 8 members.
And then the governor would do the remaining 5 public members.
Okay.
That's how I understand the language and the previous discussion that we had.
Well, wait, how many members are on this regulating governing board then? Because I'm lost.
So it's 13 members.
Okay.
7 are public members. That is to say, they don't need to be lawyers and often aren't. And then there's some rules about who would appoint them. And then there are some rules about what kinds of expertise need to be in the governor's list of appointees. And then 6 that are appointed by the Supreme Court, where we're talking here about the rules that would limit the Supreme Court's discretion. It would specify what kind of expertise the Supreme Court needs to look for in Justice Zeland's proposal is you have to look for expertise of 4 different kinds, which could be in 4 different people, or you could, I suppose, have a twofer, someone who'd both worked in a self-help center and was an expert on legal ethics, for example. And then we're not specifying, all 6. We're only specifying expertise of at least 4 different kinds. Does that answer your question for clarification, Marta? And do you have?
And I think we could it say the proposed Sandbox regulated governing board would consist of a total of 13 members, 7 of which, and then go on. I mean, I think it would just be nice to have, if the governing board's going to consist of 13 members, then I think it'd
be nice to have a topic sentence that had the word 13 in it. I hear you. Okay. So we'll take that on board. I think Mary might be making some specific notes. We'll let her react. Mary, are you willing to take on as a friendly amendment?
Yeah.
13?
Well, I haven't actually, I think I'm not sure, I think the only motion right now is Justice Zeland's.
You're right. Thank you for correcting me. So you can think about what you want to do on that subject, but the only thing we're supposed to be discussing is this substantive change that Justice Zeland wants to make to the last sentence about the Supreme Court's expertise. Did you have comments on that subject, Mary?
Yes. So I'm not, I think this is fine. I have a slight concern about narrowing what was a broader category, the provision of legal advice and services to lower moderate income Californians, to something that's more specific. But I'm persuaded by Justice Zelan. But I don't like the self-help lawyer. For one thing, I don't think that's specific enough. I'm willing again to accept the notion that someone who has experience with self-help legal centers could bring valuable experience. I don't think that person has to be a lawyer. And I also don't like framing this in terms of people as opposed to experience. So I would suggest a slight reframing of this language to say, so with experience with legal ethics, comma, federally funded legal services providers. So take out A to make sure clear that we're talking still about experience. Take out A and then self-help, add self-help legal centers, comma, and then we don't need that. Then we don't need a lawyer with experience we just take out the regulation of legal services. So self-help legal centers, comma, and then the regulation of legal services. But that's obviously that suggested amendment is subject to Justice Zelan accepting that.
I consider that a very friendly amendment to my amendment.
All right, so it's accurately captured now, Mary, in the way you think it should read, and Justice Zelan in the way you think it should read. And if so, I'm going to ask Patricia Scutera whether it's agreeable to her as the second.
I agree.
Okay, then that's the motion before us now. And Kevin, you have a comment or question?
Question, just a clarification. When we talk about public members on the committees I've been associated with the state bar, they're always non-lawyers. And is that the assumption, or can a public member appointed by the legislature be a lawyer? I'm asking out of curiosity, and I'm thinking with one of the third options in a later discussion we're going to have about lawyer involvement, that the Board of Trustees suggested in a letter to the legislators of having, lawyers owning at least 50% of Sandbox entities. So now we have a board, and I recognize that boards are weighing of late toward having non-lawyer members in the regulation of legal services. But I'm just wondering if we need any more clarification on this as to who these people are going to be. Mary mentioned just now that a self-help person doesn't necessarily have to be a lawyer. Person who has actually worked in self-help doesn't necessarily have to be a lawyer. And I'm just thinking of the reaction of lawyers. I belong to a number of lawyer listservs, and I know that certain articles get published about the work we're doing, and boom, you get a circulation of emails complaining, what are they up to now? So I'm just wondering if we could have a little bit more clarification on what is being suggested.
If Mary wants to respond directly to that, I'm going to let her, but I would point out that you're not on the subject of the motion. So I want to return us to the subject of the motion, which is Justice Zelan's proposed change, as soon as we get an answer, if Mary wants to offer one to.
I think Kevin's question is asking, what is the definition of public member? And i.e. whether a public member can be a lawyer. And I don't know the answer to that. This is the language we've used from the very beginning of our governance discussions, and this has never come up before, and I don't know the answer to that.
Okay. My recollection is that we thought it was not a lawyer, but I don't know whether there'd be a legal prohibition on the legislature putting in a lawyer as the public member. So I don't know the answer to that either. Wendy.
Thank you. I think the issue about lawyers I've raised previously, that the proposal doesn't include folks who actually practice law to the same extent. For example, the medical board includes individuals who actually have a license to practice medicine. It seems to me the completely wrong direction to not include attorneys. And it also seems to me to be more of this anti-attorney bias that I frankly don't understand, that's permeated the process. And so I think the public members absolutely should include attorneys, and that actually the structure itself should include attorneys because they understand what the ethical rules are, as well as the duties to clients in a way that—
Wendy, just to jump in, the Supreme Court makes 6 appointments, one of whom must be an expert in legal ethics, and one of whom must be an expert in the regulation of law-related services. So while it doesn't say that the Supreme Court appointees must be lawyers, it seems that the Supreme Court's appointees will largely be lawyers based on the expertise that's required and based on the fact that it's the Supreme Court that's appointing them. So just because the public members may not include lawyers doesn't mean the board wouldn't include lawyers. And I just wanted to be sure we weren't confusing the two.
I appreciate your feedback, but again, with the medical board, the majority of individuals are those that actually have practiced medicine and actually have a medical license. And I don't understand why you would want a regulatory entity over attorneys who don't understand or have the same experience with the ethical rules. And this does dovetail in other areas like the standard of care. Having a minimal standard of care to me is non-negotiable. I frankly don't understand the bias against these very basic consumer protections. I think having attorneys who understand the ethical rules and the ethical obligations with penalty of losing your ability to make a livelihood, I think is extremely important. And I continue to maintain that position.
Okay, so as a sort of a process point, we're still discussing Justice Zeland's proposal, and we're going to vote on it as soon as there's no more discussion on Justice Zeland's proposal. Then if there are other motions that someone wants to make, we are open to them, but we need to know what the motion is and whether it has a second and so on before we would discuss it. So just a heads up to be working on that, Wendy, if you choose to. Betty.
Thank you. I put in the comments how a slight proposed revision to Mary Baldwin's proposed revision, just to clarify a little bit that we're not talking about one person with all of that experience, but I also changed it to expertise, similarly along the line of what Wendy was just saying. This is crucial, and lawyers take a separate exam just on the sorry, I lost the word. Ethics, our ethical requirements and what we have to do. And it's, of course, one of the biggest areas where lawyers get in trouble. So I do think that being a little bit mindful here of more carefully selecting the group. I mean, what is experience? What, is that 6 months working, volunteering someplace, or what are we talking about? So I would change that to expertise.
Okay, so I'm going to ask Mary, as soon as she's ready to answer, whether she will accept Betty Williams' edits as a friendly amendment. And Mimi, maybe you can help put them on the screen for us.
Well, I don't, I appreciate that. I don't know that expertise is defined specifically. For example, someone with a self-help center, what does it mean to have expertise in self-help legal centers? I don't know what that means.
I agree. Similarly, experience isn't defined either. So maybe we say requisite experience, sufficient experience. I mean, I understand this is all just a big proposal, but still, maybe if we put some kind of language in there that would draw the attention to whomever is going to make that decision, that it's not.
Well, it's the Supreme Court is going to make that decision. So, it's a question of what language is sufficient to give them, good direction that they would appoint people who we would consider sufficiently qualified from our perspective. So,
Okay. I guess I just think expertise is a higher standard than experience. And maybe the script doesn't agree that that's necessary. It just was a thought I had.
So I appreciate the thought. And just as a point of order, I think the way we need to process it is to see whether Mary will accept as a friendly amendment or not. And just speaking generally, when a friendly amendment is not accepted, it doesn't become part of the proposal, but it could be voted on separately as an amendment after the original proposal is voted on.
I think it's actually technically Justice Zelan's decision.
Oh, I'm sorry. Of course it is. I apologize. So Justice Zelan, would you be open to considering Betty Williams' suggestions as a friendly amendment?
It seems a little awkward just in the phrasing of it, because expertise with seems, I don't know, odd. I'm being an English major now. But I wonder if we could say, use the word significant experience, and whether that would address Betty's concern that it not just be somebody with one toe in the water.
I agree with that. It's still not defined, but it does imply something more than a minimal threshold.
Okay, so if we could add the word significant, Mimi, before the word experience in the language that we have there. And then I'm going to ask Patricia as the second whether she agrees with this as a friendly amendment.
I agree.
Excellent. Then I think we have a motion. Brady, do you have a point of order for us? You're on mute.
I was just doing a bit of research to make sure I had the citations correct. I just wanted to provide a tiny bit of information on the public member. At the state bar, talking about the state bar bodies, it's typically been a non-lawyer. Business and Professions Code sections 450 through 453 discuss the definition of a public member for organizations that are or for agencies that are part of the DCA, and those.
What's the DCA?
Yeah, and so that includes excludes, both licensees and people who have recently worked in the industry. So that's just to give a sense of what is generally meant by public member. I think that's a good source to look at.
Brady, I wasn't clear because I don't know what the DCA is about.
I'm sorry, the Department of Consumer Affairs. So that's many of the licensing agencies in the state.
So that definition of public members would govern us, and therefore
would not necessarily. I'm just saying that's an example of how it's been defined and understood in the law. And,
I see.
Yes.
Okay.
I'm sorry. What is a public member then under BMP 450 through 453?
It excludes both a licensee and generally people who, I'm paraphrasing here, have worked in or represented the industry being regulated.
So public member, if the BMP code were to be used, the public members, the 7 public members of this regulatory body would not be lawyers, could not be lawyers.
Correct, because this is the legal industry, correct.
All right. I don't know where we are procedurally with this, but I'm going to echo Wendy's concerns at the fact that we are putting together a governing board that does that, the majority of which cannot be, or there's a possibility at the very least that they cannot be lawyers, is breathtaking.
Okay, so what I'm going to say to you is the same thing I said to Wendy, which is that's not the motion we have before us now, but we're very open to whatever motion you or Wendy wants to make. We did, I mean, you say breathtaking. This is something that we discussed and decided previously, so it isn't coming out of thin air, but it ain't over till it over. So if you all want to propose a change to it, by all means do, but do so with a specific motion. I have Mary and then Eric, unless Brady is still having his hand raised on purpose.
No.
All right, and Mary neither. So Eric, you're on.
So this is just a Brady or I had thought that the way we were treating public members from this previous discussion, I'm reaching back a little bit, is not market participants. So this would not eliminate lawyers. So, you know, people who have a law degree are members of the bar, have at some point practiced law, but that it was excluding that these public members could not essentially be competitors to a potential entrant into the sandbox, right? So that would both include not the CEO of another, you know, legal service provider, but also sort of people in a law firm. So I had thought the way we decided public member was we were using that language to say these are people who do not have an interest as a competitor, because in theory under the sandbox there would be two ways of providing legal services, right? You could provide them, you know, in a traditional law firm, or you could provide them in some other sort of entity. And so I didn't think this excluded lawyers in the sense that people with legal training or experience. I thought this was excluding people who might view the services being considered by the sandbox as competition. And Brady, correct me if I'm wrong, or Bridget, I feel like this was a discussion you and I had a while back, so.
Okay, I'm going to table that discussion because it is not relevant to Justice Zeland's motion. And I'm going to ask if there's any more discussion on Justice Zeland's motion as it stands before us now. That is to say, the motion is to edit the last sentence of this governing board description in the way that's now shown on the screen.
This is Wendy. I'd like to make a friendly amendment.
What's that?
Friendly-ish amendment, that the majority of the governing board have to be licensed California attorneys.
I second that.
I'm not understanding that. What are you amending to say that? Because you're
The language of of what the governing board shall consist of licensed members of attorneys.
okay. So Wendy, that's not a friendly amendment to the motion that's before us, because the motion that's before us is a sentence that starts the Supreme Court's nominees would include. So if you want to hold that thought, please do. But we're just talking about the one sentence that's before us. Any more discussion on Justice Zeland's proposed amendment or Justice Zeland's motion? Seeing none, I would ask that Mimi call the roll on that motion.
Just a point of clarification. So we are amending recommendation 6, which was previously approved. We're amending this one sentence in that recommendation, correct?
Yes.
Not a new recommendation, we're just amending that one sentence.
Well, aren't we just amending the draft working? Well, we've been talking about this in the context of the draft report, which we don't have a pending motion yet, right?
That's right. So I think the motion could be phrased, the working group recommends that, and then just read the sentence. The Supreme Court's nominees would include blah, 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 blah.
Okay. It's just, so this is not a new this is a new recommendation.
This is a new recommendation. It doesn't have a number yet.
Okay, that's
the
all.
recommendation is the working group recommends that.
Okay.
And then the sentence that we've been editing up there.
Okay, so the motion is to approve this sentence as shown on the screen. Mary Baldwin.
Yes.
Becky Sandifer.
Yes.
Marta Alkenbrock.
No.
Andrew Ruda, Wendy Chang, David Engstrom,
Yes.
Dan Grunfeld, Eric Helland,
Yes.
Kathy Huang, Micah Star Liberty,
No.
Kevin Moore, Wendy Musell,
No.
Lucy Rica,
Yes.
Toby Rothschild, Patricia Gutierrez,
Yes.
Sacha Steinberger, Betty Williams,
Yes.
Lori Zelon.
Yes.
The motion carries.
Okay.
Eight,
Thank you.
830.
I'm sorry, I was muted. I raised my hand to try and
Okay.
get your attention. I voted yes.
Thank you, Kevin. 930.
Okay, so now I would like to return to Wendy to continue whatever presentation you want to make with regard to the draft chapter or motion.
I would like to make a motion, Wendy Musell, that the majority of the regulatory board be licensed California attorneys in good standing.
Okay.
Second.
Just a point of order that we have 13 members, and if the majority are attorneys, then we would need more appointees by the Supreme Court, correct?
I don't think that's a point of order, Mimi. Thank you. We have it's a comment that's a helpful observation, but we have a motion and a second that we adopt a proposal that's different from what's in this language, and we would have to figure out what the consequences for the language are. And I'm being reminded that we have at 12:30, which is, oh dear, which is in only 8 minutes, a presentation. And I meant to give everybody longer than 8 minutes to get your lunch together before our presentation. So what I'd like to do is to break here with the motion pending, and we will come back to it after the presentation and after lunch. We have a 12:30 and then 1 o'clock presentation. And Wendy may or may not have more that she wants to say at that point about what she wants her motion to be. Since I think the agenda item is considering the entirety of the draft chapter. But we'll put that on hold and let everybody take a brief break, because we're due back at 12:30 to hear from the first of our 2 presenters. Sorry that I lost track of time and I'm leaving you so little time to go gather your lunch. See you soon.
Okay, great. Thank you, everyone.
I'd like to welcome 2 people who weren't with us this morning. The first is Mark Toney, member of the State Bar Board, who's one of the 2 ex officio members to our committee.
Thank you. Happy to be here.
And the second is Noella Sudbury, who I believe, Bridget, you're going to introduce.
Yes, just briefly. Thank you, Noella, for being here with us today. And I'll just do a quick introduction, but you feel free to give more of your background, Noella. But she's the owner of Sudbury Consulting and has 10 years of experience in criminal law, data-driven policy, legislative strategy, and project management. And she is a graduate of the University of Utah School of Law, and she's here to talk to us today about a product that she has pending in the Utah Sandbox. And so she's here to give us a little bit more background about that project.
Awesome, thanks. It's great to be with you all. Sorry, it took me a couple extra minutes to join. Can I share my screen with you all? Let's see. All right, let me share this. Let's see, nope, present. Okay, can you all see that okay?
That's great.
Awesome. Okay, I know I don't have tons of time, so I'm going to talk very fast, but I'm happy to answer any questions you have and share my contact information at the end. So as Bridget mentioned, my name is Noella Sudbury. I'm a lawyer by training. I graduated from the University of Utah back in 2009. So been practicing law for about a decade, started my career as public defender. It's where I really got my passion for criminal justice reform and how I sort of like circled back. I've done a variety of things, but for the past about 5 years, I've been kind of knee deep in expungement policy work, expungement practice work. And in February, launched a new startup called Rasa, which is in the Sandbox. If you look on the proposal, it's still under Sudbury Consulting. We have a name change pending. We are the same, and our mission is to make the process of clearing a criminal record simple and affordable for everyone. So it's a little bit about my background. These slides will talk about just the problem that we're trying to solve and how we're trying to solve it, and kind of our approach to this in Utah, and also explain how we're using Utah Sandbox and how we need models like that to do what we do. Okay, so first the problem. So the problem that we're trying to solve is this: 1 in 3 Americans has some type of criminal record. And having a criminal record prevents people from doing almost anything in their lives, accessing a job, getting stable housing, going back to school, repairing their credit, being a meaningful participation, being a meaningful participant in their child's lives. We talk to a lot of parents who actually the record hasn't been an employment barrier, but they want to be a chaperone on a field trip. And the school's got a policy that because you have this record, you can't do that. 20 to 30 million Americans, the good news is, have records that are eligible for clearance under existing state laws. The problem is that these systems for clearance are costly and complicated. Each state has their own scheme of who's eligible. It's very difficult for somebody to figure out whether they are eligible, and then representing themselves is very difficult to do as well. Most people find that they need a lawyer to help them through this process. Unfortunately, most lawyers charge between $2,000 and $3,000 to clear a criminal record, which is out of reach for most people. This picture to the right is Amy. Amy works for me at Rasa. She is one of the 800,000 plus Utahns in Utah living with a record. She is about to finish up her social work degree at the University of Utah. And as I'll talk about later, is one of our non-lawyer support advocates that help us in the Sandbox. So who's eligible to clear their record? As I mentioned, every state has different rules. Here are the rules in Utah. I'm not going to go through them, but if you look across states, you'll see statutes like this that are created by state legislatures. It's super complicated. And for most people with a record, they just throw up their hands because their records are often scattered across the state. In California, there's something like 58 different court systems where records live. Most people need to get their records to determine under the statute if they're eligible. There's often costs associated with getting the records, and so people give up. What's the process? Similarly costly and complicated. I joke that if you have to reduce the font to fit on a PowerPoint page, like it's probably too complicated. But it's multi-step. It's decentralized in most states. If you have multiple convictions across multiple courts, you need to file separate paperwork in each one of those courts. A lot of self-represented people are not allowed to e-file. They lack transportation. They don't have a lot of income, working sometimes 2 to 3 jobs, have kids. And so unfortunately, what we know from the data is that 75% of people who try to represent themselves fail. In Utah, so what's the gap? Uptake rates, and you saw maybe a link to a study on an earlier slide done by Colleen Chen, who's done research on this nationally. She's actually a researcher out of California on how many people who are eligible to clear their records actually apply for an expungement. What her research shows is it's less than 10% of people everywhere. In Utah, it's less than 2% of people who have records who file petitions each year. So sadly, you just see most people completely left behind. this is kind of the backdrop for how I got involved in this work initially for clean slate laws. So for people who haven't heard of a clean slate law or an automatic clearance law, the idea of clean slate is this: the government actually has all of the information that it needs now to know who's eligible to clear their record. We have a statute with the criteria, and the records are housed in courts and departments of public safety. And so the question for lawmakers with clean slate was, we have this long, complicated, costly process, but 90% of these are granted. And so might there be a subset of those cases where maybe we don't feel like that process is adding much, right? Maybe people shouldn't have to go through that process and hire a lawyer or try and represent themselves. Perhaps the government can just use our statute and our records to identify someone's eligibility and clear their records automatically. Utah was the second state in the nation to pass a law like this. Our law passed unanimously in the Utah State Legislature in March of 2019. Very difficult to implement. I know you've had some challenges with this in California as well. This is new for the government. It's a big shift. We don't do anything automatic in the government. But this law went into effect on February 10th of this year. And what it does is shift the burden from the individual to the government. So Utah is automatically clearing records now. Utah's clean slate law automatically clears misdemeanor A, drug possession, most B's and C's and infractions if an individual has remained crime-free for a set period of time. According to our data, over 450,000 Utahns will have at least one record cleared under Utah's clean slate law. So we're done, right? We have automatic clearance. Wrong. More work to do, and this is true now. So Utah was the second state in the nation to have a law like this. There are now 9 clean slate laws. So this is a movement across the country, which is very exciting. However, there's 2 issues that remain, and this is true of all states. Number one, these clean slate laws do not have a direct notification requirement. And so what that means is the government's going to spend a lot of time and money automatically clearing records, but we have no way for people to easily know. And so Pennsylvania, which was the first state in the country to have a law like this, their law went into effect, and all of a sudden we've got a line of 8,000 people who are trying to talk to lawyers to figure out whether they qualify. This is problematic. We automated the process, but we haven't created an automated solution. Second, not all cases qualify for automatic clearance. In Utah, you can get both misdemeanors and felonies off your record. But only certain misdemeanors are going to drop off. And so this adds, unfortunately, kind of a layer of complexity to that analysis, because there are many people who have felony records or misdemeanor records that don't qualify. Maybe some of their stuff dropped off, but they still have things on their record that have to go through that old court-based process to get cleared. Rasa was formed to address 2 of these issues. So what are we doing? We are developing software to manage this process for the person. And we are more specifically developing 2 products. Our first product is a web application that allows a person with a record to type in their name, date of birth, we'll verify their identity, and we will tell them what is on their record, what is eligible for expungement, both now and the future. So more specifically, this will include what is eligible for automatic clearance, petition-based, court-based clearance. Maybe they're in a waiting period. They have something on their record that's eligible next year, or maybe they have the type of offense that doesn't qualify for expungement and they need a pardon. So this web application will give individuals quick advice as to what their options are. Second, if they have things that are eligible for clearance but need to go through that court-based process, we will represent them for an affordable price. So as I mentioned, most lawyers in the private market charge $2,000 to $3,000 to clear records for a person who has 2 or 3 records, sometimes more than that. Rasa will offer to represent that person for just $500. How do we get there? We are building software to help streamline the process. Our software will use those same court records that we have access to generate paperwork, to move the person's cases through the government. We've got to serve the prosecutor, identify the right court, file it places, and communicate with the user every step of the way, right? You have just wanted to let you know your cases were filed with the court today. The next thing that you can expect is we're going to wait to hear from the prosecutor. The prosecutor has 35 days to respond. You'll hear from us when we hear from the prosecutor. So all throughout the process, we want to keep that client informed of what's going on as their cases are moving through the government. Now, we can't automate everything with software. And so to the extent that there are manual steps required in the representation of the person, we are training non-lawyers to assist with that work. The Sandbox is also needed for this. We have chosen to hire individuals who have been through the expungement process themselves to stand in as lawyers and handle certain aspects. Specifically, we have permission for Amy, who you saw on that first slide, to give basic legal advice, prepare documents, negotiate with prosecutors if that's required, and file documents with the court. She is not allowed to represent people in hearings. We have lawyers who are available to do that if we need to, but we know that's rare. And so for most cases, Amy can almost handle the matter from start to finish with the assistance of our software. So why now, and how do we use the Sandbox? There is an incredible amount of expansion in this area, in the record clearance area. And so as you can see from this map, in the first 6 months of 2021 alone, 25 states passed over 50 laws expanding expungement eligibility and making changes to the process for someone to get their record cleared. You're also seeing a huge rise in clean slate laws. As I mentioned, those are automatic clearance laws. None of those laws have that notification requirement. And so in order to have effective implementation of automatic clearance, we're hoping that our web application tool can help people across all states know what their rights are. Oops, went backwards. Let's go forwards. How are we using Sandbox to do this? The Sandbox allows us at Rasa to do 3 things. Seek outside capital support so that we have the resources necessary to do this work. This is non-lawyer firm ownership. Using software to provide basic legal advice to someone through our web application. And 3, training non-lawyers to provide certain aspects of the legal services in order to develop a cost-effective alternative for a person with this problem. So this just goes into more detail here about our mobile app. So our mobile app is powered by court records. And so what that does for the person, rather than ask them, how many misdemeanors do you have? How many felonies do you have? What was the date of resolution? We have that information. And so we have pre-analyzed that data set to figure out who in the state of Utah is eligible to clear the record and what they can get cleared. And then, as I mentioned, if an individual has eligible records, we'll offer to handle their case for just $500. Why $500? We did a lot of surveying of folks with records, and that seemed to be a price point where we could afford to provide the services and not go out of business, but also for someone who's looking to expunge their record. Most of them are working. They can't afford $2,000 to $3,000, but they can afford $500. And so that's that pricing. We are actively serving clients now, and that pricing seems to be affordable for people. Between 50 and 60% of people that we meet with now hire us. So very high conversion rate. And I think from that, we can take away that $500 is going to be a lot for some people, but for a lot of people, it's doable. Because we are very mission driven, we are also partnering with nonprofits, government partners to sponsor people. And so we do have certain kind of like pipelines of grants. If somebody really doesn't have resources, if they, were a victim of the opioid crisis, we have a nonprofit that allows us to sponsor that person if they meet certain criteria. And that is also a way for us to serve people for whom that price point is not going to work. This just describes our backend case management system that we're developing in more detail. And this, I love to show this slide. This is the before and after slide of Amy, who works for me. Amy is a person in long-term recovery on the left. These are both Amy. She was homeless. She was, she had a routine bunion surgery that was, something went wrong. 13 surgeries later, she was addicted to opioids. She got cut off from opioids and became a heroin addict. She became homeless. She lost everything. Amy has now rebuilt her life, is graduating from the University of Utah with a social work degree, and she now works for Rasa. She is amazing. She's so smart. She's detail oriented. She's passionate. She has this immediate credibility and trust with our clients, and she is 100% capable of doing this work. But we need the sandbox to do it. Here's our impact. This is my last slide, and then I'm happy to take questions. Clearing records has an immense impact on people's lives. As I mentioned, less than 10% of people across the United States who have records have made it through the clearance process. Reduced employment for the millions of Americans with records hurts our US economy. And helping people clear their records improves public safety, reduces housing instability, and strengthens our economy. The number one reason people reach out to us is to get a better job. And people with records are 63% more likely to get a job interview. And just 1 year after clearance, their wages go up by over 20%. So our work truly does make a difference for people. Unfortunately, we've set up processes that make it almost impossible to get this relief without sandbox models and innovation to allow that to occur. So I know I talked very quickly and I've only left 8 minutes for questions, but I hope that was helpful, Bridget, and what you had in mind.
Noella, that was fabulous. Thank you very much for the great work you're doing and for sharing it with us. It looks like Patricia Scatera has the first question for you.
I apologize if I missed it and you said it already, but my question was more like in terms of logistics. Are you leveraging that system to submit documents? Because if so, I was wondering if you've experienced any glitches in the system that were not resolved immediately and caused people to have their documents submitted late into court so that it wouldn't be admissible. Because I know there's some sort of court timelines and stuff. I don't know what it's typical procedures or whatever it's called. Sorry, I'm not a lawyer.
Nope,
so.
no worries.
Yeah.
So the first thing to say is we're still in development of that back end.
Okay.
Eventually, we do want all of those documents to be submitted to courts in as automated as a way as we can. Right now, we do have some document automation in generating the pleadings, but we are still having our non-lawyer advocates be trained to review and manually file those with the court. But what I would say about your concern is ultimately, we are not a self-representation model. We are actually representing the person. And so if a deadline were missed, like we're going to be accountable for that. We are their lawyer. And so we have checks in place to stop those things from occurring. And so even as we look to automate more and more of our processes, ultimately it's us responsible, not the person. And the reason we set it up that way is because 75% of people who represent themselves fail, even with navigation assistance. Does that answer your question?
Absolutely, thank you.
Thank you. Mark Tony has a question.
Thank you, Justice Tucher. Noella, great presentation. Thank you very much. A couple of questions. How many states do you currently operate in?
Right now, just Utah. We launched in February. We hope to expand, but
that's fine.
We need
How
the
does
sandbox to
Utah
do that.
handle regulatory fees? Is it a flat fee? Is it a per capita fee? I'm just curious.
And by regulatory fees, you mean like government fees that the person would have to pay, or?
No. how much do you as a vendor?
Oh,
have to pay
as a
for-
participant in the
it-
sandbox.
Yeah, in order to
Got
be
it.
cover the regulatory costs. I'm just
Right.
curious.
Yep, I
Okay.
don't pay anything for that.
It's a
Our-
pilot. Sometimes pilots do that. That's cool.
Yep.
We'll move to my next question. What is the employment status of your non-attorney advisors? Are they independent contractors or are they employees?
They're employees. Right now, we just have one of them.
That's a good answer. Thank you. I'm done.
Thank you. Wendy Mussel has questions.
Hi, I wondered what sort of agreements do you have when there's been legal malpractice? For example, if there's been a mistake, and then what sort of standard of care are you required to follow? And third, do you have an arbitration clause if there is some sort of dispute or malpractice such that it's in private arbitration as opposed to court? Thank you.
Yep, so we carry malpractice. We have a malpractice insurance policy, and we have found a malpractice provider who will extend that coverage to our non-lawyer advocates. So all of that is governed by our policy. Our standard of care is the same as it would be for any other lawyer, and that carries on to our non-lawyer advocates as well. In terms of an arbitration clause, it's actually a good question. I don't think there is one. Nothing that we have in our engagement letter would require somebody to arbitrate. Hope that answers your questions.
Thank you, it does.
Are there other questions for Noella? Well, Noella, thank you very much. That was really interesting. Even I think I could say inspiring. And I appreciate you making the time to come in and talk to us.
Sure, absolutely. I just put my email in the chat to the extent anybody has any other questions for me. Would be happy to chat. So thanks for the invitation. Hope it was helpful in what you had in mind, and best of luck with everything going on in California.
Thanks very much.
Thank you, Noella.
With that, I'd like to move to our second presenter, who I believe Lucy is going to introduce for us.
She there?
But I don't see Lucy on my screen.
I don't either, and I see that James is here, so I think I will just jump in.
Oh, there's Lucy.
There she is.
But
Okay,
she's
good.
on mute.
I'm
Okay.
here. I'm here.
Okay.
Yes. So I am, let's see, he is here. Yes. Okay. I'm pleased to introduce Dr. James Teufel, who is one of my colleagues in the Office of Legal Services Innovation. He is currently our head of data. And we're really lucky to have James working on the Utah project. He's also working on the Ontario Legal Sandbox. He has over 20 years of professional experience in the areas of legal innovation, public health, medical legal partnerships, evaluation healthcare, and psychology. And he has really brought a data scientist's mind to our work, and is the person who is responsible for the intake of data each month from the entities that are regulated through the Utah Sandbox, and reviewing that data, identifying whether within that data there are any concerns that we need to address, and preparing our very comprehensive reports that go to the court each month, and also preparing the public version of those reports, which are less comprehensive due to business confidentiality concerns. So we are lucky to have James here to speak with us. Thank you, James.
Great. Thank you, Lucy. And I'm happy to speak at the group, but I'm also more than happy to speak with the group. So, you know, I can also start out, right, instead of giving a presentation, right, on the front end, I'm more than happy to start this with any questions now, and then go into a presentation that'll also help me maybe adapt what'll be important to the group, because I do have some lived understanding of how both Utah and Ontario are playing out in the world with regard to their sandbox approach. But if there aren't any questions, I'm also happy to start speaking.
Well, let me take a quick moment and see, understanding that to be the general topic, are there any particular issues anyone wants to flag at the front end to make sure James covers in his presentation? If not, we'll just let him speak and then have questions after. All right, Neil has a.
Just how each entity handles consumer complaints.
Okay, great. And by entity, meaning each Sandbox, Ontario versus Utah. Okay, so great. I can start there. So in Ontario, this idea of handling complaints is still a hypothetical concept, right? Because although they have accepted applications, they have not launched entities into the point where they would be reporting data to this point. However, the processes both in Ontario and Utah will be fairly similar, right? So both Ontario and Utah will be collecting periodic data. The frequency of that periodic data will depend on in Utah, what we call risk level. Your higher risk level, the more frequently you report to the office. In Ontario, it's more along the lines of innovation level. In reality, how these things play out is it's very similar. So the further you are away from traditional legal practice, the more frequent your periodic reporting. The closer you are to traditional legal practice, the less regularly you report to either office. And the reporting will be basically a quarterly or a monthly reporting basis. And what we do is we look at service level data. So this isn't case level or consumer level data. We nudge entities or projects to report service level, legal service level data to us. And we ask them for complaints as it relates to those services. Does that answer your question?
Yeah, thanks. But is there a direct reporting mechanism for consumers to the regulator?
Yeah, so in Utah, and we're going through this process now because we changed our website. And what we're asking entities to do is to have a badge on their website. We have on our website an area where complaints could be filed to the office, right? So they can click on a badge through their website that'll redirect to our new website where you could report that way. In addition to direct consumer complaints or proxies of those consumers complaining, we also require and ask that our entities report any of the complaints that they receive as service providers and report those to the office on a periodic basis. Great. So I'll make certain assumptions, and knowing half of my assumptions will be wrong, but there's another hand up. So Patricia.
Just quick question. How do you enforce or, do an audit to ensure that if anyone is reporting directly to that entity rather than you, that they are actually giving you those complaints? Is there something in the back end system that would be triggered to let you know, to do some sort of, I don't know, just to double check?
Yeah, so it's a good question. So in Utah and Ontario, similar schemes, different words for them, right? Is when we use audits in both of those regulatory systems, the audits apply to essentially what we would call moderate innovations or above, or moderate risk and above. So these would be non-lawyer provision of services in some way, shape, or form, software provision or human provision as well in Utah. We audit those services at least once while they're in the sandbox, and we audit 20 services in Utah. In Ontario, they'll probably audit 30 services to look for the quality of the service, right? Is the service producing harm in the areas of rights, results, or issues of payment? So for our higher risk or higher innovation entities, we incorporate quality audits where we look at their services. We have 2 external panelists who are lawyers in Utah who review the services for those issues of rights, results, or payment. So there is an additional audit quality check from that standpoint. When we receive a complaint, we follow up with the entity. We try to better understand what the complaint was. And what we're also interested in is not just if a complaint existed, but was there a reasonable or satisfactory response to that complaint? And we have entities describe that. So to date, when there has been a harm-related complaint in Utah, responses have been satisfactory from entities so far.
Thank you.
Great. Any other questions? I think I could see some people, but not all people. Great. So I'll move into a talk. Some of this will be higher level, some will be more granular, but I'm always open to answering any questions the best I can. And if I don't answer a question well, please let me know, and I'll try to answer it better. So both Ontario and Utah share this sandbox concept. And in general, the sandbox concept is to try to better understand innovative goods, services, and policies in the world. And as you better understand those things, usually through data collection, you can better inform what policies and practices should be adapted or improved or put into the world into the future. That's an important concept. And this idea of innovation is an important thing. It's both in Utah and it's in Ontario. And an innovation is simply any new idea, product, or service or policy for a person or group of people. So an innovation is not necessarily an invention. So what we will see both in Ontario and in Utah is potentially different uses or different ways to deliver similar things that have existed in the world, just doing it in a different way, right? So it doesn't need to be something new to the world in total. It could just be a variant of old service delivery models just done in a different way that would have been ordinarily not allowed if it were not for the sandbox. So that's the general concept behind a lot of this. And one of the things in sandboxes to consider is there's essentially at least 2 or more adoption curves playing at the same time. So if you have a new thing into the world, in a sandbox, you're going to have 2 adoption curves that follow basically the idea that you're going to need one group of adopters. Those are going to be the people who are going to provide these services, right? So you need entities or providers or projects who are willing to adopt and engage in a sandbox. And then if you're able to do that, which Utah's been able to do, so Utah has more authorized entities and applicants than all other sandboxes in North America combined, even if you add Arizona to that mix, if Arizona were to be considered a sandbox, although it's a rule change. Utah's had a lot of uptick in adoption. We've had, I believe our current count is now, this was our last month, was 71 applications. I think we're over 75 applications to this point, and we have 43 authorized entities. So that's the first adoption curve that you would want to look at in a sandbox, is how many entities are applying and how many entities are authorized. In Utah, we have a lot on both of those sides. The next adoption curve you would look at is the services. How many services are produced by these entities or projects? So in Ontario, this concept is still underway. They just, I believe, formally approved the first entity in Ontario this last month. In Utah, we're in a much different position, right? So Utah, we've seen over 23,000 services delivered to 18,000 unduplicated users of those legal services. So Utah is on the adoption curve higher than any other sandbox that exists in North America at the moment. And we're still learning from that work. Some of the things that we're learning are things like when we look at complaints and we try to understand what complaints mean, right? We could look at the individual complaint level, and at the individual complaint level, what we see is similar to what they see in the UK. When you get a complaint, about half of those complaints fit into our harm framework. And when we look at what happens with regard to response for those complaints we receive, most of well, at this point, all of the responses have been satisfactory to complaints. The entities have taken responsibility to make it right with their consumers when the consumer has complained of a potential harm. So, and when we try to contextualize this further, we've tried to do this in Utah a little bit. is if we try to compare the service to complaint ratio of a traditional legal practice to these sandbox practices, we find the ratios to be very similar, which is also found in the UK context, right? That our more innovative services are resulting in no more harm than traditional legal practices. Any other complaints before any other questions before I go on? I'm sure there's a lot of complaints.
Can you talk to us a little more about how many complaints there have been and what sort of things have caused complaints?
Sure. So out of those 23,000 plus services, we received 11 complaints. 5 of those complaints fall outside of our harm framework. So to fall within our harm framework, it clearly has to be related to an issue of a legal right, a legal result, or something resembling a poor payment issue. So certain things, of our complaints, all but one of those complaints are for basically lawyers within an alternative business structure. One of those complaints is for an alternative legal provider, so a non-lawyer. When we look more deeply at what these types of complaints relate to, is one consumer was upset because they didn't receive their service they expected, and the reason for that was the lawyer lost the email or phone number for that person, right? So this is a problem, right? You shouldn't do that, but these are things that happen in the world, and they made it right with the consumer by, refunding them any money and trying to provide them services. Other complaints that emerge in the world are things such as, complaining about the timeliness, right, of response or the amount of award received. All again, things that are common complaints in the legal ecosystem. There haven't been any complaints that, for example, would say, this is because that this is an alternative provision of service, right? We haven't seen those complaints yet. What we've seen is these are complaints related to legal services that would be similar complaints that would exist in traditional legal service realm. They happen to be in this other sandbox legal service domain. Does that help to answer your question? And if we break that down, we can break it down further. We break down our complaints of the 6 that are harm related. 1 is payment related. I believe 2 were results related, and 3 were rights related in how we break that down.
And since it sounds like half your complaints didn't fit within your rubric, can you just give us a sense of what those are? Maybe some examples?
Yeah, I mean, it's going to be things where I'm trying to think of one off the top of my head. That would be the best case example of this. I would say where they fall is around issues, of nuisance, but not an issue of results, right? So I didn't like how my lawyer spoke to me, right? I didn't like the tone of the person. I didn't like how they treated me. I would have expected that a lawyer type person to give me better service, right? That, doesn't really fall, these are personal grievances of communication style or timeliness of communication, but that doesn't necessarily directly hit our harm framework unless that communication issue is also related to a problem of a right or result or payment. Yes, Mark.
Thank you. I'm curious what you do, James, to track the regulatory costs. It sounds like, you've got to review applications, there's some rule setting, complaints, monitoring, a whole host of activities, that require staff time and other expenses. And what do you do to track regulatory costs? How do you do that?
So we do have a budget, right? An ongoing budget. And with any innovation, especially innovations that start small, we have to be very vigilant about our budget because there is not much variance at the end of the year in our budgets, neither in Ontario nor Utah. Utah and Ontario have a very different budgetary structure. So Law Society of Ontario internally largely supported the project with internal funds for a 2-year period. and they have something called convocation that they'll then go back to after that 2-year period to see if they could be re-up for their money. Utah largely was funded off of grant funding, right? And so on top of making sure that you need to track your budgetary expenses in a more traditional in-house investment way, there's also grant regulatory requirements that have to be met there with regard to reporting on budget and expenditures and things like that. In Utah, the courts offices, right, budget staff help us with tracking some of these expenditures, and they have a grant manager that helps us with reporting and things like that. Does that answer your question? If not, I'm happy to elaborate.
Much of it. So when we're looking at the sources of revenue to cover the regulatory costs, when you say grant funding, is it private grant, public grant? And I'm also most particularly interested if there are any restrictions on who you can and can't accept grant money from.
So in Ontario, that hasn't been an issue yet, so I'll leave them off the discussion point. In Utah, we have money from SJI. We also have funding from Hewlett Foundation. The question of, is this an acceptable grant mechanism or not, hasn't emerged. What has emerged is to make sure that we can carry out whatever we're promising in grants and to make sure we're responsive to the funder. But there hasn't been a question of, for example, is there some undue influence of this funder on the project yet? That has not emerged into it.
Okay, thank you for that. Now, part of my question is, look, it is not surprising that when you're starting a project, you figure out a way to subsidize the cost, okay? In any project, when you're trying to build a market for it, okay? So I have no issue with that. I guess my question is, what are your future thoughts about sources of funding? Are you looking at regulatory fees that the participants would pay? Do you have a goal of those regulatory fees being sufficient to make the regulatory activities self-sufficient? I'm just curious what you, and if you haven't got there, that's okay. I'm just curious because these are questions we have to think about here in California.
Yeah, so I could wear different hats. However, I would like to answer this question. One thing that we know in innovation is that you typically want to, in some way diversify your funding, and to make sure that you have funding from different sectors and areas in order to protect yourself across time. And in Utah, we are considering the concept of a fee. Now, do we believe that fee structure in Utah, how we're currently thinking about it, would cover costs in total? Probably not, but it would offset some costs into the future. The fee structure that we're considering in Utah at the moment would be based on a revenue concept, right? So one idea in Utah was, and I think this is a legitimate concept, and Ontario is using a similar idea, is we did not want to charge fees up front, because what we do know in the world of entrepreneurship and innovation is if you want to squash small businesses and entrepreneurs, then charge very high fees up front. And that'll also significantly cap the innovation that you put into the world. However, in the long play, the idea would be if some of these entrepreneurs come to fruition, right? And we know that in how entrepreneurship works, it's a numbers game, right? You have to have a lot of things to have that big success.
Yeah.
Down the line, then we could be talking, right, in a handful of years. Now we're looking at a higher proportion of our costs being covered by these fees when you have very successful entrepreneurs move from that world into this new world where they're generating a lot of net revenue.
Thank you, James. I appreciate it.
Yes. Hopefully that was an answer.
Thank you.
Yeah.
Marta?
Thank you. Back to what you were just saying about the funders. What is SJI? Who is SJI?
So SJI is, what is it? The State Justice
State Justice
Institute.
Institute.
Yeah, State Justice Institute. Yep.
Who funds the State Justice Institute?
I think they're actually a statutorily created funder. So I can get you more information on them, Marta, but they
So
are,
they're probably funded by the legislature then of Utah?
no, they're federal.
Oh, it's federal. Okay. And then does Utah have any conflict of interest kind of processes in place to look at who they're going to accept money from for funding the Sandbox?
You want me to take that, James?
Sure.
So
if you'd like to.
this we defer to the administrative office of the courts
Mhm.
and their budget management policies and processes. So we sort of defer to their to that body, and so any grant proposal goes through them before it's formally made to any funder.
I second what Lucy said, so I don't have anything to add.
Does California have that same process? California have a budget manager that would look at whether or not a funding, a grant could be given to a regulatory body? Alrighty then, I guess we'll table that question.
Right. Thank you. Go ahead, James.
Great. So there's other questions that will emerge as people do engage in sandboxes, right? Not all sandboxes are carried out the same for various reasons. Typically, with a sandbox, right, you want to allow for something resembling innovation, experimentation, to create new things in a safer environment to understand how they may work in the world. Related to that, and a lot of my background is in health, there's different ways you can carry out that regulatory function. And Lucy and Tom Clark just wrote a great white paper on some of these concepts. It emerges in both what we see in Utah, in Ontario, and other places. Similar questions will come up, right? Of what are the goals of what you want to do, right? Do you want to make legal services more efficient? Do you want to create a better marketplace? Do you want to have better outcomes? Do you want to ensure that people are not harmed? Do you want greater legal empowerment? Depending on what is chosen, right, has either that creates some barriers to what your sandbox may or may not be, right? But also with that, there's things from the regulatory side, once you figure out what your aims will be for your sandbox, that you want to consider. And we could look at how these things played out in sort of regulating drugs in the United States, right? Something with much greater history than legal services, right? Originally, people were really concerned about food and drugs as they were imported, right? The outsiders coming in, people get very concerned when new people are doing things, right, that they don't know. And so the original concern was we need to control these imports because something bad could be coming from, it's always the other people, right, importing. After some period of time, they said, maybe it's not just those imports. Maybe we have issues we need to look at with ourselves domestically. The first thing that they tried to understand was, how do we describe what people are trying to do, right? So if you engage with sandbox work, Ontario has a lot more of a descriptive mechanism on the front end, right? They have a lot of barriers of describe exactly what you're planning to do. But in Utah and Ontario have a different approach on this. So in Utah, there's less of a descriptive barrier than Ontario. In Utah, the assumption though is that you have a business model that's closer ready to being launched. In Ontario, they have a stage 1 and stage 2 application, right? So you can have essentially stage 1 is when you're in concept development, which is a very common place for entrepreneurs. And stage 2 is when you actually have a business model, right? So in Ontario, you apply for a stage 1 application if you kind of sort of have an interesting concept, but it's not a real business model yet. And when you get to a business model phase, then you apply for stage 2, and then you're allowed to offer services, right? So there's always going to be something built into a sandbox and a regulatory function of how do you describe your services. The next step, which we saw in regulation through the FDA was ensuring that harm doesn't exist, right? And we see this also in Ontario and Utah, is how do we set up a risk or harm regulation framework? So when these services go out into the world, the bar is at least there is no harm, right? And when we look at the FDA, decades after they started to consider these ideas of harm, they got into the ideas of outcomes or quality. So there's typically a progression of how regulation plays out in the world. The first step is describe what you want to do. The next concept that usually emerges is, does it harm people? And then the third step after that is, what are the outcomes for people? And a step that even the FDA hasn't figured out yet is, how does this impact the population, or what is the social impact, right? And so oftentimes what I see in the legal space, which is it reverses these things, right? So in the legal space, oftentimes people speak about the access to justice metric, right? And that's really a population-based metric, right? Where in the health world, they haven't even gotten to that yet, and they've been doing this 100 some odd years. And so what you'll see in Sandboxes oftentimes is people talk about this descriptive stuff, and they talk about harm issues or maybe quality of services or outcomes, and they don't tend to talk about these population level impacts as much. And there's a lot of reasons for that, right? Because it's outside of usually the entity's hands itself to address that issue directly, right? They can provide services, they can be regulated for if they're harming people engaged in those services, they can describe what they do, but they usually can't be held to account for engaging an entire population health metric. Like 80% of people go unserved with legal needs or services or whatever it is. So I find that as an interesting framework when considering some of the ways to think about how regulation plays out, and maybe how in the legal space, how things play out maybe a little bit differently than the health space. I find that interesting. Other people may not, but I just throw things out because I think they're interesting. One other interesting thing that I think we see in both Utah and Ontario is when you talk about risk, and I won't go too deep into my nerdery about words of things, right? But words of things are really important, right? Risk is really a term when we fully understand how a world works and you're going to gamble on something and you know what the probabilities are, right? That's a lot of times when risk management people talk about risk. What we're usually talking about is uncertainty. And what Sandbox allow us to do is to better understand what may occur in the world as things are put into the world, right? So it takes away some of our preconceptions and we test ideas to see if we're right or not. And as we gain more information, then it gives us more certainty about saying things in the world as opposed to presupposing what those things may be in the world. So a risk or harm framework is really looking at the issues of harm. A sandbox generally is looking at the issue of the world's an uncertain place, and when we're trying something new, the world even becomes more uncertain. So let's learn about this more, let's collect data and see what happens as opposed to presupposing what may happen. Neil?
Yeah, so just another question about complaints and services. So you said 23,000 services provided, right? And then 11 complaints. Does that mean 11 individuals complained and 23,000 people have been serviced? What could you unpack that a little bit?
So we do, a little over 23,000 services have been delivered. And there are approximately 18,000 unduplicated users. So what we are seeing in the sandbox is there's a lot of, which we sort of suspect it may happen, is there's a lot of one-to-one person service matches, right? In that you would expect some of these providers to be providing like essentially like the concept of unbundled legal services, right? You need a form completed, you need a will, right? We're gonna just help you with that. Where we see the lesser than one-to-one match is in like licensing schemes, right? So when you have a business-to-business model, you have a higher number of services relative to clients. So for example, if you have a business-to-business model on improving contracts of a business, right, that they may get 30 services per consumer, whereas an individual, a business-to-person model, may have more of a one-to-one match. And to your point, Neil, the complaints are per service, but also since there's this one-to-one match, it's really also per individual, if that makes sense.
Okay, and then just two more follow-up questions. That 23,000 over 11 or in 11 complaints, that's over how many years?
So that's since the initiation of the sandbox. So this is over a little over 12 months.
Okay, and the other question I had is the complaints. Are you noticing any association between complaints and the risk evaluation when this participant entered the sandbox, or is this number still too low to do that kind of analysis?
So what we do see is, so for example, comparing the periodic reporting to the audit, like the actual service audits that we do, I can say that when there are issues with, for example, quality of data reporting, right? Are you not reporting in compliance? Do you have a lot of things that are lost to follow up, when you see a lot of lost to follow up services, what that means is they're probably not engaging in legal services. They're probably engaging in qualified leads, right? So they're saying something's a legal service, but it's not actually legal service. When we see stuff like that, what we have seen, and again, this is a small sample, that's an indication when you come to the audit, right? There's probably also going to be something else that emerges in the audit, right? And that's what we've seen so far as a trend, right? When we see elements of maybe red or yellow flags in the periodic reporting, when we've moved to an audit, we've seen more indication that there's something else to be worked out here. Does that answer your question?
Yeah, thanks.
Mm-hmm.
Marta and Randy have questions?
I think Randy was first. Do you want to go ahead, Randy?
Please go ahead, Marta. It's fine.
I may have missed it, but it was very early on in that last kind of portion of your talk that you just did. But I think you mentioned a white paper that has been recently published on this. What is that white paper?
So this is more along concepts of how do you create a framework for like these sandbox services. So Lucy and Tom Clark wrote that paper, and I think it was just put out publicly like this month or late last month, something like that. It's a well done framework to help conceptualize. You know, if you need a cookbook for how to think through which boxes to check and what your options are about in 8 different buckets, it's a really nice way to conceptualize of that cookbook, what will we select from in each of those areas. So it's an 8-course meal of how to construct a legal sandbox into the world.
Great, thank you.
Randy?
James, thank you very much for your presentation. This is all very informative. And in particular, I find very encouraging the information you're providing about what's happening inside the sandbox, the ratio of services to complaints and harm. I have 2 questions about things sort of outside of the sandbox environment. Earlier, you mentioned the badges, and it's been asserted to us and to a prior task force, the ADLS task force, that whenever there's innovation and outreach and publicity to consumers at large about non-lawyer delivery, that somehow that will serve to inspire malicious actors to leverage that messaging to prey more so on consumers in regards to UPL. And I'm wondering if you have any insights on whether the digital badges have aided in the effort to prevent that.
So, you know, I don't have a data-driven answer for that, meaning that I don't have any data to support, right, that assertion is true in the world, you know, in any way, shape, or form. We have no evidence that people have, for example, stolen the badge to, you know, engage in malicious activity. I also have a suspicion that malicious actors are engaged in activities where this badge doesn't yet give them that credibility, right? So but we have no evidence to support that malicious actors are using a badge to leverage other bad things into the world.
I was actually more curious about how the badge works to prevent folks from assuming the identity, so to speak, of a provider and using that to prey on folks.
Okay. Well, what we're actually going through, I'll try to answer what I can from a data-driven perspective with regard to badges. We're going through an audit process now, right, to make sure that our entities are in compliance with how they're using their badges. And we're also, one thing that as innovations emerge, because the Sandbox is also an innovation, we need to make sure that badges, because we know their hyperlinks probably need to be updated, that their badges, when people click on them, lead them to our website to file a complaint, because our website has changed fairly recently. So far, I think people believe that the badge gives them credibility, right? Like people proudly sort of state that they're members of the Sandbox. What we see on our websites beyond just the badge itself, when we're going through this badge audit now, what we see a lot on the websites is a lot of our entities really like to show how they're first movers, right? That they say, we're the first to do X in the world or in Utah or wherever it is. So I would say from a data-driven perspective, from what I can see, from what I know, is that people are displaying their Utah affiliation to the Sandbox proudly. What we have to make sure is that all of our entities are displaying the badge as we would like it, and that's what we're going through right now. So hopefully within the next month, that will also be an alliance in compliance with how we'd like them to do it. I don't know if that answers your question still, but that's what I have to answer.
It does, thank you, and I'll actually stand down on my second question. Thanks, appreciate it.
And I'm going to thank you for answering all the questions that you've come here to answer and the material you've come here to share. Unless there's someone who has a burning and narrow issue that they want to still lob in before we say goodbye to James. We've gone a little bit over the time that I had allocated in the proposed schedule. So I'm going to say thank you very much. Appreciate your sharing with us, taking the time to come talk to us, and we will say goodbye.
Thank you, Justice Tucker.
Thank you, James.
Bye.
With that, I'm going to give everybody 3 minutes of break. We're going to come back at 1:40 to resume our discussion agenda. Thank you. All right, thanks very much. Well, those were some very interesting presentations, and I think we had a lot of productive discussion and some action this morning. We're going to go back to, we're still on business item number 1, the proposed draft chapter on structure and governance of the possible Sandbox regulator. And there was a motion made and seconded just before the break, made by Wendy and seconded by maybe Marta, was it? I'm not sure. Mimi, can you remind us who seconded Wendy's motion and what the motion was?
Sorry, I'm trying to find the screen. Oh, here we go. So the motion was made by Wendy Musil. I didn't have a second, but the motion is for the majority of the regulatory board to be licensed California lawyers in good standing.
All right, I'm fairly certain there was a second. If the second could identify his or herself. Wendy, do you remember who seconded your motion?
It was me. I'm back. I'm sorry.
It was Marta who seconded. Good. That was my recollection, but I didn't have confidence in it. So if the record could reflect that that was the motion that was made and seconded, we do need to have a discussion on that specific motion now before we get to other aspects of the proposed draft chapter. But I'm going to start, Wendy, by asking, because your proposal isn't specific to the language of the chapter, whether there's anything you want to add to it. Do you want to friendly amend yourself, or is that the motion you want to have stand?
How I envision this would be when there's any discussion, the language where it starts the discussion about the composition of the regulatory board, that those be the prefatory statement, so that whatever the constitution of the board is, it must have a majority, and the word must or shall should be used, must have a majority of attorneys licensed in California who are in good standing. In good standing, of course, referring to disciplinary with the state bar.
Okay. So I'm going to open this motion up for discussion. I have Lucy, then Neil, then Mary.
Justice Tucker, I have a preliminary question before the motion be
Yes.
put forward. Is I thought we already voted on this, that this was a decision that had been taken and was done.
So you're right that it's a decision that was taken and that was done. But nothing is not subject to being revisited. And this is an appropriate time to revisit it because we have taken everything that was previously decided, put it in one place and said, okay, does this all make sense? Does this all cohere? And are we still of the view that it's the right thing? And so just as we entertained and passed a motion from Justice Zeland to make a tweak, we now have a motion to make what I have to acknowledge is a more substantial tweak and will require a more substantial revision if it passes. But that's why I think it's appropriate to address the motion on the merits at this time.
Okay. Well, I would just add, I don't actually have a problem with requiring a majority to be lawyers. I would just like to include language that at least 6 are non-lawyers. So, you know, if 7 are lawyers, then 6 are non-lawyers. Because I would, you know, I think a big part of this effort is bringing diverse voices into this process, and particularly when thinking about new entrants into the legal services market, and remembering that no decision is going to be made unless the Supreme Court, which is at my last check was all lawyers, would approves it. So I would, if I were to vote for this amendment, I would like to say at least 6 are non-lawyers, so that it doesn't end up being, you know, 10 lawyers and 3 non-lawyers.
Okay. Neil.
Yeah, so just to my memory and recall of this back when the language was first approved, at least the way I was interpreting it, I was interpreting that the 6 members would be appointed by the Supreme Court would be attorneys. That was my recollection. Maybe I was off on that. The other thing is maybe you also want to consider doing what I guess the Arizona ABS does. The Arizona ABS has judges, and actually, sorry, Utah even has judges, I believe, in their Sandbox board. You know, the court, you know, does, you know, control the practice of law, and I think having judges' voices may be useful here. So I'm just throwing that idea out there. I took a quick look over the lunch break about the structures of the boards for the Utah Sandbox and the ABS committee. The ABS committee has 2 judges, 4 public members, 5 attorneys. The Utah board is, the rule there for the standing order in Utah, as my understanding is, it doesn't give a specific breakdown, but it says 11 members, at least 5 of whom should be public members. So I'm just putting those out as comparable points.
Okay, thank you, Mary. And then Eric.
Thanks. So I have some recollection of when we did this, you know, originally and came up with this plan, that there were antitrust concerns that were baked in, and Eric or whoever read to us the language earlier about public member, that was, or maybe it was Brady, that was coming from the perspective of, you know, the market participants versus non-market participants. And I just, so that's one concern. And I don't have that expertise, and I don't recall specifically the discussion. So maybe somebody who actually does have expertise could address that to make sure that we're not running afoul of that as we reconsider this decision. But also, if we are going to change it, and I don't have strong feelings about it. You know, I sort of, you know, whatever, if that's what we want to spend our time doing, that this is fine. But we can't just say, since we've been so specific about who gets to appoint whom and how many. I think we have to be more specific than simply throwing out this, pronouncement that at least, a majority have to be licensed California lawyers in good standing. I think we have to figure out how that requirement is going to affect these categories of appointments that we have spelled out in this language.
Okay, before I call on the next people in line, can I ask if anybody can respond specifically to Mary's point about whether there's an antitrust constraint that requires us to be talking majority non-public minority lawyer? Because I also recall that was an issue, and while I don't recall thinking that we needed to go this way, I think it was an issue that some people were thinking of when we originally chose to go with the majority non-lawyer board.
I'm going to reach back and say that I'm not the expert on this who proposed it, although I appreciate Mary mistaking me for that person. But I think the idea was that there had been a series of cases on these regulatory boards that they could not be made up of a majority of people who were practicing in that area. So dentists or hairdressers or sort of whatever it was. So I think what we were trying to avoid was that the people that were involved would not be accused of, say, rejecting an application because it would directly compete with their sort of business. So I think that was the notion of public, was that public here, the lawyer, non-lawyer, in the case of the bar, the public members are people who are not directly involved in the provision of legal services. But of course, in our instance, we could have, say, judges who would not be competitors in the market for the provision of legal services, who would be lawyers and I presume, lawyers in good standing. That would be a public member. So I think we were trying to sort of have a system where the majority were not, both for antitrust reasons, but also to send a signal that this was not an attempt to block entry, but that people would sort of get a hearing because they wouldn't be competing with the entity that was requesting entry in the legal market. And so I guess I feel like we're kind of conflating two things here. One is sort of legal expertise that can be held both by people who are competitors and people who are not, and also with the idea that we do want a majority on this board to not necessarily be perceived as bias against entry. That doesn't quite answer your question, Justice Tinker, but I think that's what we were getting at with these series of antitrust cases, was that it couldn't be a government cartel, essentially trying to sort of keep people out.
Okay, thank you. Was that what you had your hand raised to
It
say?
was exactly it. So.
Okay, Marta.
Thanks. I also remember a discussion that the members that were going to be nominated by the Supreme Court would be lawyers. I have a vague recollection of that conversation as well. But my true concern was what Brady raised earlier, that public members, that phrase has a meaning within the BMP code. And if those terms are used in conjunction with the BMP code, they could mean that people that hold a license cannot be part of this group or cannot be on the board. So I think we need to be very careful, even if it's a footnote saying that BMP code, whatever, doesn't apply. And I think we need to study that a little bit more to make sure that we're not stumbling into something that we don't want to happen here by using phrases that may have import within the regulatory land or landscape rather. Thank you.
Thank you. Kevin.
Okay, I sent off an email to Randy, and I also did a little research of my own on the Board of Trustees of the State Bar. And the Board of Trustees have 7 lawyers and a maximum of 6 public members. That's how the statute reads. Right now, there are 6 public members on the board, and I'm inferring the other 6. There are only 12 listed on the State Bar website. I don't know whether that's updated, whether it's accurate, but there are 6 members. But the appointments are made 5 by the Supreme Court, lawyer members, the statute states, or attorney members, and then each of the legislative bodies, the Senate Rules Committee gets to appoint one lawyer member, and the Speaker of the House, or the Assembly, I'm sorry, gets to appoint one lawyer member. So there is, it's set up so there is a majority of lawyers. And I'm just wondering whether I'm assuming, maybe incorrectly, they've looked into the antitrust issues that might be involved there. My second point I want to make is that look at what we voted on earlier on recommendation 17 and the composition of certain members where we were doing that sentence and Justice Zealand's amendments to it. And we're talking about people who have experience in the delivery of legal services to the underserved people or unserved people. And presumably, we've been talking about many of those people are going to be lawyers. So regardless of whether there is a lawyer majority, you're going to have people who are sympathetic. But what I like about having a majority of lawyers is that it's sending a message to lawyers who are going to say, protect the public. We want lawyers involved. Lawyers are schooled, educated in legal ethics and in protecting the public. And some people might say, well, protect is part of that, but it's just protectionism. But I don't buy into that. Let's have a majority of lawyers send the message. And as I mentioned earlier in the meeting, that I'm really concerned about us going forward and what message we're signaling to the legislature, because they're going to hear about whatever we vote on today. If not by looking in themselves, they're going to hear from lawyers what we do. And I'd rather see us show that we're here. And yes, we want to increase the delivery of legal services, affordable legal services, but we haven't forgotten that other part of our charter, which talks about the protection of the public. Thank you.
Thank you, Kevin. Toby.
Just a real quick, the comment earlier about judges. Judges are not lawyers in California. They're required not to be members of the bar. But if you look at the definition that Mimi posted in the chat, that for at least the Board of Trustees, you can't be anybody who's ever been licensed by the bar. So judges would qualify or not qualify as public members for that reason.
Thank you. Lucy.
Couple things. I think the antitrust concern, if what we end up proposing is similar to what's been done in both Utah and Arizona, the antitrust concern is less of a concern because of the active role of the court. So the problem in those other contexts was, and what has become a problem with regard to state bars, is that the court is not taking an active role in the regulation. And so the concern of the licensees regulating themselves and the antitrust concerns are more acute, where the actual government body tasked with the regulatory authority is not playing an active role. So if we construct this properly, which is the court plays a relatively active role, I don't think it's a problem if the board has a majority of lawyers. I will say too, in looking at the public member definition, at least as it relates to the bar, I don't think it's exactly apples to apples. I do think here, and somebody said this before, I think the concern would be broader, actually, that, where a public member would be folks who are not participating in the legal services market. Because again, what we're doing here is expanding that definition. And so it would mean lawyers to the extent that the lawyers, were participating, but it would also mean, for example, legal technology company, representatives and that sort of thing, I think. So we, I think it would probably, if we get to this point, we may, and I don't know if it's in our bucket or someone else's, to clarify that definition as it would apply to this structure.
So I would like to propose a friendly amendment to Wendy that I think builds on what a lot of people have said, but there are multiple pieces to it. So Mimi, if you would scroll up to the beginning of governing board so we could see this, and write in as I go along what I hear emerging from people, and see whether this is something Wendy wants to go with. In the first line where it says should have a volunteer governing board, add the words of 13 members. Then in the next paragraph where it says the proposed Sandbox Regulator governing board would consist of 7 public members, cross out 7 and put 6. Then down at the bottom, we could do this by footnote or other or parentheticals or whatever. We would say, or actually, let's just do it by parenthetical, by 6 public members. So after 6 public members, open a parentheses and say non-participants in the legal services market. Then when we get down to the Supreme Court's nominees would include, so a couple sentences further. Okay, exactly, they got the right sentence. Okay, after the Supreme Court's, add the word 7. Okay, so let me explain what I think I've just done and see whether I'm, oh, thank you, you're right. I needed to catch that there too. What I think I've done is to try to actualize in the language here the points that Wendy and others have made, that we should be clear we're talking about 13 people, that we should have a majority of lawyers, but we're not actually saying the Supreme Court has to appoint lawyers. It's our understanding that they will appoint lawyers and judges, and it would be up to the Supreme Court to decide exactly in which mix. But we're at least requiring, we're at least putting the nominating role on an entity that is an entity that is about lawyer expertise and not about public representation. So it seems reasonable to expect, but if somebody wanted, we could even explicitly say that the Supreme Court's appointees should be members of good standing of the state bar, or we could say members of good standing of the state bar or judges, or members of good standing of the state bar and no more than 2 of them should be judges. We could elaborate on that, but at least what we're doing is setting up a structure that is now minority public members, and we say what that means, and majority members of the legal profession of one sort or another that the Supreme Court would then be entrusted to pick. And just since we were specific about expertises, I kind of did a little count, and we're now specifying 3 of the governor's 5, which seems like 3 of the governor's 4 representatives would be different kinds of people, economist, technologist, and non-lawyer, et cetera. So I don't think that we would have to change our listed expertises. So that was on the fly, and it may not be fully responsive to what everybody wants, but I want to start by asking whether Wendy would accept that or some version of that as a friendly amendment.
Can you show where my sentence, which is the majority of attorneys, majority would be attorneys, California attorneys in good standing. Additionally, I think the other participants also should be from California, since this is all about California. But if you could show that, that would be helpful for my understanding.
Okay, so I think we would have to limit the Supreme Court's appointees to all being attorneys for what I just spelled out to embody what you, where you started. So we'd have to add a sentence at the end. The Supreme Court's appointees shall all be California licensed attorneys in good standing. So is this package of edits something you will accept as a friendly amendment?
Just taking a look at it. Thank you.
Okay, and then I will be asking Marta the same question. And in the meantime, while you're thinking, oh, go ahead.
Hello?
Yeah. Wendy, we can't hear you. You're on mute. But while she's thinking about that and sorting through the technical aspects, I'm going to continue calling on people because I think we're on the same subject area. So it's, I think, a fair process. Kevin, go ahead.
Yeah, just a picky point. Why are the word nominee and nominate used? We're not nominating people for a vote. We're appointing. Each person appoints someone. So I would just recommend that we substitute the word appoint as opposed to nominate.
Okay, so the Supreme Court 7 appointees is what you'd like us to say.
Well, throughout, wherever we use the word nominate or some variation.
Got it. Okay, so if Mimi could try putting that in as an additional potential amendment. Becky.
So I'm going to oppose this, and I just want to say a little bit about why. We've had some conversation from my colleagues about the importance of how lawyers will view this. And I understand that that's a legitimate concern, but the majority of people affected by this are not lawyers. They're the other 59 million people in the state of California. And so it's kind of puzzling to me that in order to protect that very diverse constituency, we want to make this board less diverse by setting it up to be a particular kind of person. So that's one reason that I don't like this idea. The other is that this model of regulation is evidence-based. And so what you need on this board are some kinds of perspectives and expertise about how the board should work and how it should be governed and all those kinds of things. But you also need people who understand evidence-based regulation. Lawyers have no training and no experience in evidence-based regulation, and currently law is regulated with complete ignorance of any evidence about whether those regulatory processes achieve their goals. So I think you're also you're tamping down the diversity, you're keeping out the voices of the people who we're supposedly trying to help with this, and you're also stacking this body with people who do not have the knowledge or the experience to enact the kind of regulation that this model proposes. So for those reasons, I will not support this.
Thank you, Becky. Toby.
Just a technical point. If you're defining non-participants in the legal services market, if that means people who are not earning a living practicing law, that would include a whole lot of people, some of whom are licensed lawyers, but are not practicing law. They're doing real estate. They're a friend of mine from law school went off and became a novelist, but still has his law license. And it would include judges because they don't participate in the market. So the question is that what you want, or is it something narrower than that?
Okay, thank you. Eric.
Toby, I think that just personally, the answer to your question is that is what I want, but that's just me. But I actually have a question, Toby, for you. I did not realize that judges were not members of the bar, being a non-lawyer. But it strikes me there's a lot of people who wouldn't be licensed attorneys then that would have this experience. That judges and so on. So am I right that sorry to put you on the spot, but you knew that last piece of information, so I'm just going to assume you know the next one. Would that last sentence then eliminate a lot of people who potentially would be overseeing, say, court-assisted, legal services provider, something like that, that wouldn't necessarily have to be bar members, but would be attorneys? I guess I'm asking independently, how concerned about that last sentence in terms of who it restricts out should we be?
I guess for me, I think for the most part, as I understand the self-help center statute and rules, that the people who run those, in charge of those, are in fact lawyers. Particularly the court-operated ones, but even the privately, the legal services program-operated ones generally have lawyers in charge of the self-help centers. So that doesn't bother me. And I think that the list of lawyers that are, the ethics and legal services provider and self-help, the one that doesn't necessarily have to be a lawyer is people who are, I forget where the wording is, significant experience in regulation of law-related services. Not quite sure what that gets, but I think those might not be lawyers.
I guess I'm just wondering if, I don't mean, this is, I just worry, we're excluding potentially law professors who would not have, who might live in California, but not have, taken the bar or be a lawyer in good standing. We're excluding judges. I guess I'm just trying to get a sense in my mind of how restrictive this is, but I think.
So I'm gonna jump in here and say, I attempted to do on the fly something that I think I probably couldn't manage on the fly in amending the proposal. But basically, the language that we started with here was something that this group had voted on and approved before. And the amendment that we discussed and adopted was one that was at least served up to everybody by email yesterday. And the ideas that have been coming on today, we've made a good faith effort to try to accommodate, but it seems that we are not going to reach we're not going to reach closure because the issues seem to be proliferating rather than resolving. So I realize that Neil and Lucy both have their hands up, and I will call on them before we leave this issue. But after that, I wonder whether there is someone who would like to move to table further discussion of the description of the governing board, so that those of you who have views and who've been making points can contribute to a fully fleshed out proposal or series of proposals, the way there are options 1 and 2 and 3 and so in the memo that we'll be talking about shortly. But just that it's not the best use of this group's time to continue hearing things for the first time rather than having a chance to, well, for the first time today, months after we previously resolved the issue, rather than being able to decide amongst things that were teed up for the meeting. So with that, Lucy and then Neil, if you still have issues you want to raise because your hand was raised before I came out with that, please do.
Neil, did you want to?
Yeah, go ahead, Lucy.
No, I was just going to say, again, having that recognizing the fact that this was decided in the past, I almost would like us to go ahead and vote on this proposed Wendy's motion. But I would say the only thing I was going to say was a change to the last sentence that said, to the extent that the Supreme Court appoints attorneys, they must be California licensed attorneys in good standing, because I do think having judges is important.
And just to follow up on Lucy, I kind of agree that it would be nice to have that flexibility. There are certainly lots of judges that know how to weigh evidence and assess evidence, right? That's what they do. And also judges that would have experience with legal ethics, and even judges that sit on boards that involve federally funded legal service providers, right? So there's room, but I think the way the language is right now, you could not include a judicial officer in this, I think. So
I think that's right. So Wendy, you've been asked to consider as a friendly amendment changing your proposal to allow for judges, but simply saying to the extent it's lawyers, they should be attorneys in good standing from California. Do you accept that as a friendly amendment or no?
No, but thank you.
Okay. So Marta has something to say. I don't know if it's a motion or what, but go ahead, Marta. Oh, but you're on mute.
So sorry. I just want to underscore what Wendy mentioned earlier, that the I think all members of this board should be from California, should be California residents. So while it looks like now that the Supreme Court appointees are California licensed attorneys, I think that we still need, this is a California-based program. I think they should all be from the state of California, California residents, all members of the board.
Okay. So Wendy, you've been asked to make various friendly amendments, and I don't know if you want to accept any of them or if you want to just have us vote on your original motion, which was just the one sentence.
I would accept Marta's friendly amendment that all members need to be California residents.
Okay, and Marta was the seconder, so we know she accepts her own friendly amendment. And assuming that's the only thing, I think what this means is rather than looking at any of the language that we're looking at right here, which is all going to be, which I take it Wendy and Marta are not accepting, we're just voting on an independent resolution, not on this exact language. And the independent resolution is that the Supreme Court's, at least in substance, and maybe Mimi has the language more precisely written down somewhere, that the Supreme Court's appointees shall all be California licensed attorneys in good standing, and all members of the board shall be California residents. Is that what your motion is, Wendy?
Yes, thank you.
Okay. So if you could highlight that one sentence for us, Mimi, that's the only sentence we're voting on.
Don't we technically have to vote on flip-flopping the 6 and 7 as well?
No, we're not doing any of that because Wendy didn't accept any of that as a friendly amendment. If I understood you correctly, Wendy.
Well,
I guess the sentence that's here doesn't say majority. Yeah, so why don't we go back to Wendy's original motion, if you can read that, Mimi, from your records.
Yeah, it's a majority of the regulatory board must be licensed California lawyers in good standing. And in order for it to be a majority, we would have to change 6 to 7 and the 6.
Yeah, but we're not doing any of that 6 and 7 stuff. We're just going with Wendy's motion. So the sentence you just read us, plus the friendly amendment, and all members of the board shall be California residents. So what we're voting on has no reference to what's,
okay,
you know, the rest of what's
My
on.
apologies. I could also accept the amendment about the 7-6 because you're right.
Okay.
You can't have a
that's
majority
important.
without it being.
Thank you.
Okay.
I
So,
understand and thank you.
So Wendy, can we, and presumably you would also accept the friendly amendment to put in 13 members in the first paragraph. So we're clear that we're talking about 13.
Yes, thank you.
And are you accepting the friendly amendment of a definition of public members, non-participants in the legal services market?
No, thank you.
No, okay. So if you can strike that. Are you accepting changing the word appointing to nominating? Excuse me, the other way around,
Yes,
nominating
thank
to
you.
appointing. Okay.
Yes, thank you.
And so now, looking at all, can you see all the text, I hope, on the screen? We don't see you, but I assume you can see the text. Wendy?
Yes, I can. Thank you very much.
Would you accept that the current language of this governing board section is your motion?
Can you give me just 1 second to look at it? I want to make sure the language about the California folks
Yes.
is in there. Let me
I
just
think
make
that's
sure
at the
that's
very
there.
end. And Mimi can add a comma between standing and in the last line. And then Marta, I'm going to ask you whether you accept this as your the motion you seconded. Okay, Wendy, you are on mute if you're able to tell us if this captures your motion. And Marta, although we haven't heard from Wendy yet, if you could take yourself off mute and tell us if this captures.
Yeah, that looks good. Thank you for the moment to review. I appreciate it.
Okay, perfect.
Yes.
And Marta? Okay. So now we have a motion that's been made by Wendy, seconded by Marta, and amended only in the friendly manner. Is there other discussion or are we ready to vote on this? If you want to say something further about this motion, please raise your hand.
I can't find the hand raising button.
That's okay. Your method works. Please go ahead, Patricia.
I would like my minor opinion noted because I'm going to vote no, and that's because I'm not comfortable with excluding judges from that opinion based on what I thought that judges could be part of this, and the explanation of the evidence-based decision-making and their expertise.
Okay, so I appreciate you letting us know why you intend to vote no. I will note, just as not because I'm supporting it, but just as a procedural matter, if you or anybody else who wants to make further changes to this wants to make a motion after this, you're welcome to, but that'll be on a separate basis because we're voting on Wendy's motion now. For a moment, I saw a hand raised, but it went down again. Any further discussion of the motion before us? Okay, seeing none, I would ask Mimi to call the roll. The motion before us is that we adopt the language that's currently on the screen describing what we want the governing board to look like.
That is correct. All right, Mary Baldwin,
No.
Becky Sandifer,
No.
Marta Alkenbrock,
Yes.
Andrew Aruda, Wendy Chang, David Engstrom, Dan Grunfeld, Eric Helland,
No.
Kathy Huang,
No.
Micah Star Liberty,
Yes.
Kevin Moore,
Yes.
Wendy Mussel,
Yes.
Lucy Rica,
No.
Toby Rothschild,
No.
Patricia Scutiero,
No.
Sacha Steinberger, Betty Williams, Lori Zelon,
Sorry, no.
No.
This is Betty.
and then no from Lori. Okay, the motion fails. 4-9.
Okay. So thank you for that productive discussion. I'm trying to figure out exactly where that leaves us, and I'm going to start by putting things back on Mary's lap as the person who presented this draft chapter to us. Don't take everything out yet. Let's see, Mary, are there any pieces of what, for example, appointing instead of nominating or specifying 13, any pieces of what's on the screen that you want to keep as amendments?
Yeah, I would move to approve the language as amended, with the exception of taking out that last sentence, starting with the Supreme Court's appointees.
Okay, so your motion is that we specify 13 and that we have a majority of the majority being Supreme Court appointees
Yes.
and the 6 public members.
Yeah.
Okay.
So, and I would support that because I appreciate the discussion that's happened, and I'm open to this redistribution, but I'm not in favor of tying anyone's hands with respect to appointing lawyers or California residents, and I don't think that's the right thing. So that's why I took that out.
Okay, Mary, may I ask you for a friendly amendment, which you may tell me is biting off more than we should chew right now, but would you like to make a motion with regard to the entire draft chapter, including these amendments you've just made?
Sure. Let's, and we can go back to our recommendation 18 on the first page of this agenda item. So in just that language, but as with this section as amended.
I'll second that.
Okay, we have a motion that's been made and seconded to adopt the draft chapter with the amendments that are showing on the governing board. And it's been seconded. So the discussion, I'll start with Mary and Eric. And if you've both said your piece, I'll move to Betty.
This is just and since I actually seconded this, Mary, this is totally up to you if this is friendly, but I kind of liked Justice Tucker's language about non-market participants clarifying this issue of what we mean by public. I think, you know, in this document, maybe some other people, there was a lot of confusion as to what we meant by public members. And I think people immediately went to the bar. So I liked your addition, Justice Tucker, of putting in non-market participants.
I did too. I didn't realize that had come out, so.
So we'll see if Mimi can recreate it. It was a parenthetical exactly where you are.
Non-participating.
Non-participants in the market for legal advice and services?
No, it's illegal provider.
Market services market.
Non-participants in the legal services market, I think is what it was.
Okay.
I think it was.
Okay, so that's been friendly amended and accepted by
Yes.
the mover and the seconder. So Betty Williams, you're next up.
What about a sentence at the end that says something like any lawyers nominated to the governing board shall be members in good standing?
Of the California State Bar.
Right.
So Mary, that would still leave open the possibility of judicial members, but would require that any lawyers be members of the California State Bar. Do you consider that a friendly amendment and wish to accept it?
You know, I don't feel strongly about it. I don't see why we would tie the Supreme Court's hands in that regard. I think they can make a good decision about who to appoint. But if it will help move this along so we could get to some other stuff, I'll accept it.
Okay, so Mimi will try to recreate those words while I call on Marta.
My friendly amendment was something similar, that the Supreme Court's nominees be California lawyers in good standing or California judges within the state of California.
Usually the term of art is judicial officers in our state, but.
That's fine.
So Mary, the focus is all on you because you're the motion maker.
I understand. I'm just I don't understand why we're being so protectionist around California, and it's making me uncomfortable. And again, I think the Supreme Court has the expertise and the wisdom to appoint people who will be suitable for the position. So, you know, but if we can accept it, but I'm not inclined. I'm already way past my comfort zone in terms of micromanaging this appointment process and in terms of our protectionism around California. So
I'm going to continue taking comments. I'm going to continue taking comments while
of course
you figure out what exact words you will or won't agree to.
I'm saying I'll agree to this.
Okay. So Kevin Moore.
I'm just going back to the non-participants in the legal services market. That's pretty vague to me. I'm sorry, but it's not something I've ever seen before in a legal statute or a legal rule.
Well, we are not drafting a statute. We're simply drafting a recommendation. But if you have a specific proposal that you want to put on the table, we are open to it.
Okay, there's public member is defined in Business and Professions Code 6013.5, which deals with public members of the Board of Trustees. And it says it's a member of the public members of the public who have never been licensees of the state bar or admitted to practice before any court in the United States. Now, you don't have to change the language on this resolution if you just drop a footnote and say that's pretty much what you contemplate by using non-participants in the legal services market.
Okay, while Mary contemplates how she wants to react to that, I'm going to call on Lori.
Just to make things more complicated, if we're tying the Supreme Court's hands, There are lots of judicial officers, speaking as one, who have retired, but still have relevant time information and perhaps expertise. Maybe if we're going to tie the hands, we might loosen a little bit to allow retired judicial officers.
Thank you. Eric.
Mary, I don't know if I get to disagree with you as the seconder of the motion, but I would rather not have the last part in. If we want to take a second vote on that later on, attorneys in good standing in California residents, I like you am concerned this is too restrictive, and I guess the second one, Kevin, on the non-participants in legal services, the problem I have is that there are other people we want to exclude with this. We also don't want people, say, who are already have a Sandbox license and are already operating in California, but might not be attorneys, right? Because they also would potentially be in a position to want to block entry that might compete with them. So I actually think it's almost that it's not broad enough if we just use the kind of standards, because we have an unlicensed practice of law statute in this state, saying the public members are not attorneys works for the, sort of the bar. But for us, it's different, right? We actually want to exclude, we want people who are not going to look at an application and say, oh, I want to block this because this is a potential competitor, or even have the appearance of doing that. And so I almost feel like the reason for Justice Tucker's clarification is to say, this is kind of a new entity. Non-public here means something a little different. It means people that don't have an interest in keeping other participants out of the market. And I don't think the appeal to what the bar is doing, it's a little different once you are talking about something that removes the unlicensed practice of law, or relaxes it for Sandbox entrants.
I think by Eric declining to entertain the friendly amendments that he just declined to entertain, that means they won't be considered. They can be the subject of a subsequent vote, although I'm hoping we will conclude this agenda item soon. I have Betty Williams and then Marta Alkenbrock. I would ask, if possible, that people make their final comments now so that we can move to a vote on Mary's motion soon, if at all possible. So I think, did I call on Marta already?
No, but
okay.
I'm just kind of lost in the language, and I don't know exactly what we're voting on with Mimi's the things that are down below. I just need to see it. I think we all need to see the entirety of the language as we're considering whether or not we're going to vote on this language or not. And I'm a little lost.
My understanding is that all of the language at the bottom, starting where the cursor is now with any attorneys and going on down, has not been accepted as a friendly amendment because Eric said he wouldn't accept it and he's the seconder. Right. So the proposal is just for everything, well, exactly, for the paragraph above that and the highlighted paragraph. So the motion is to adopt the draft that circulated last week with the amendments shown in these two paragraphs and not any of the notes below that were things people said that have not been accepted.
So if I thought Mary accepted, I think it was Betty's amendment that any attorney be appointed be a member of good standing in California. I thought that was accepted by Mary. Are you saying
I think she accepted it and Eric said no, but if I got that wrong, no. I want the two of you to correct me because I want this to be accurate.
You have that correct.
Yes.
Okay, and since we need the mover and the seconder to approve a friendly amendment, this is the motion as it stands. Wendy, I think you have a comment or question.
I just want to give a
a view of how this is going to look outside of this meeting. What this proposal would say is that you could have a disbarred attorney, an attorney who is not practicing a good standing, who has littered with ethical concerns, be part of the regulatory committee making decisions. Also, the legislature has made it very clear that this is a California regulatory agency. We are not Utah. We are not Canada. We're the 6th largest economy in the world. We have a great deal of expertise. I find it a fallacy that we would not have Californians who are qualified to serve on this regulatory entity to the extent that it gets off the ground. And I think that it is ignoring the comments by the legislature, who's made this very clear that they don't see themselves as another state, that we're uniquely Californian, and this is a California regulatory agency to allow entities either from abroad, the UK, Canada, or from other states such as Utah or Colorado is a non-starter. And I just feel like while we're having this internal conversation, a lot of the concerns of the legislature just simply are being ignored consistently. And I'll leave that at that. I think that has further consequences.
Okay, thank you. Eric, any final comments, or is that a vestigial hand?
No, small point of clarification. I just want to be clear. The people that you are describing, Wendy, they would have to be appointed by the Supreme Court or the legislature or the governor. So presumably the vetting process, someone with extensive violations who is disbarred or Canadian, they actually have to be appointed by the Supreme Court. So I just want to be clear, there is a check here independent of, how much we prescribe this.
Thank you. Kevin.
Yeah, my only suggestion, because I think the most important change is the switch of the majority. And I'd like to bring in the folks who made the original motion. And can we use some of the language that's in our charter that talks about California experience or experience in California legal market? I can't remember the exact language that's used, so that we could bring in some people who might be non-residents of California, but who are familiar with the California legal market. But I think that it would be a shame that we don't at least send the message that we are looking to bring in lawyers. And I recognize Becky's concern about that and diversity, but I do agree that the legislature is looking at this. And if somehow we can bring in the concept of California as part of the membership qualifications, yes, there are going to be others, there are experts, but I'd like to bring more people into the fold on this particular issue. And I'm focusing primarily on the composition between lawyer and non-lawyer as opposed to California. But if we can get a California statement in there, I think that might bring more people into a yes vote. Thank you.
Okay, thank you. I was about to call the vote, and you've asked that there be some kind of change, but I'm not quite clear what your request is of Mary and Eric that they consider as a friendly amendment. So if you want to state what your specific request is, or if Mary and Eric know whether or not they, based on the general point, have a reaction, whether they'll accept it or not, I would love to hear from the three of you. Otherwise, we can certainly, after voting on this, if we can have a follow-on vote of some kind if need be. But
yeah, all I remember is that an issue was raised in June at our June meeting about certain members on the working group, all of whom had
I remember that issue,
right?
Kevin,
And
let me be clear. I remember that issue. It's just that if we're going to ask for a friendly amendment, we need to know what we're asking Mary and Eric to accept. And maybe Mary and Eric know enough that they know whether or not they accept this. Maybe they want to form the words around your idea, but I'm just trying to figure out how to move forward your.
Here's something that I would propose. I'm willing, if we, Mimi, could you just scroll down one line? I'm willing to include any attorneys appointed to the governing board shall be in, I'm willing to say, shall be California lawyers in good standing.
Okay, I think you said that before and Eric said no, but maybe in light of
Oh,
Kevin,
maybe.
he's prepared to say yes.
He did. I guess I just wanted to go back to something Kevin said just for a minute before which was, Kevin, I thought you were saying that you wanted to change the experience to California-based experience, which that seems less restrictive to me, right? I mean, you're simply saying, you know, that, and I think it would be the line, 7 appointees would include members with significant California-based experience with, I don't know what California-based experience with legal ethics, how that would be different, but I interpreted you slightly different than what Mary was saying. Am I wrong about that?
Yeah, I was trying to broaden the category from beyond just California licensed lawyers, but also it could be lawyers who have extensive experience, or I think the word we used above, the significant experience in California in the delivery of legal services in California.
That would bother me less than being sort of more prescriptive, you know, in the way that I think that sentence is, because I think what you're saying is we're making a suggestion to the legislature, the governor, and the Supreme Court that people with expertise in this particular legal market should be prioritized over people who don't have that experience within these areas. Am I interpreting you correctly?
Well, I'm not. All I'm trying to say is I'm trying to get votes. So what I'm trying to say is just to make it palatable to everyone. I don't think you necessarily have to be a California licensed lawyer to be familiar with the legal problems or having actually been involved in addressing the legal delivery of legal services problems here in California. And I'd hate to lose any of those people by restricting membership in the board to a California licensed lawyer who may have.
Kevin, what is your specific amendment? I'm just not understanding, and I'm happy to
All
consider
right,
it.
so it would be, shall be California lawyers in good standing or lawyers in good standing in another jurisdiction who have significant experience in California.
Can I ask whether anyone who is otherwise inclined to vote no would find that sentence helpful and would vote yes because that sentence was included? Because I heard Kevin say that his goal here is to gain votes. And so I think the real question is there somebody for whom something like this is dispositive? And if so, is this the thing? You see Marta shaking her head no. I can't see whether Wendy is shaking her head or smiling. So I don't know. I definitely want to get as many votes for this if we can by making a change. But if making a change is not going to make a difference, I would just assume that we move towards getting a vote rather than spend more time on something that won't cause a change. Wendy, do you have a comment?
You know, my positions haven't changed, that I think it should be California and licensed California attorneys. I mean, it's only 13 slots. We have hundreds of thousands of attorneys in the state of California that are currently licensed. And so while I absolutely appreciate the discussion and I appreciate the attempt at consensus, I really do, but it doesn't change my position.
So Wendy, if Mary and all were to accept the first half of this last sentence only, that is to say, if we were to add any attorneys appointed to the governing board shall be California lawyers in good standing, period. Does that win your vote for this proposal?
I think it goes a long way, but it doesn't address the other issues. But I deeply appreciate it and thank you for the thoughtful discussion.
Is there, of course, because my goal is to hear everybody out and incorporate everybody's wisdom and everybody's views. Marta, would the sentence without the portion that's currently highlighted win your vote? Or is there anybody else who thinks that that would be dispositive? I'm not trying to put anybody on the spot. I'm just trying to make sure we're doing something that somebody actually thinks is an improvement.
While I appreciate Kevin's comments, what he added, I'm not in favor of. And I also am, I think we're doing something for California citizens. This is the practice of law in delivering of legal services to its citizenry. I think we need to have California-based people on this board. So that's my problem with this as a whole. So I would be voting no.
So if we added the sentence that says any attorneys appointed to the governing board should be California lawyers in good standing, and we also added in the first paragraph before it says 13 members, something that said 13 residents of the state of California, so that we're clarifying that everybody who's on this board needs to be a resident, would that win your vote?
That could.
Okay, and Wendy, would that win your vote?
Clarifying, does that mean there would be 7 licensed California attorneys? So the majority would be licensed California attorneys?
It would be, everybody would be a resident of the state of California, and 7 of them would be Supreme Court appointees who, if they were attorneys, were California attorneys in good standing, but we are not saying the Supreme Court could not appoint a judicial member instead of an attorney for 1 or more of its 7 spots.
If there was a friendly amendment that it would be a judicial officer and or licensed California attorney in good standing, because I don't have any problem with it. Judicial officers serving, as long as they're California judicial officers.
Yeah, I think we had judicial officers or retired judicial officers. Okay.
California, if they were California, not from another
right.
state. Among that, and then attorneys, I think that covers the ambit of the concern that I was raising.
Okay. How about if we take out, let's move the language, Mimi, who are residents of the state of California, take it out from there. And instead, at the end of this, okay. So after footnote 6, we're going to have any attorneys appointed to the governing board should be, after footnote 6, why don't we say all members of the governing board and then use the language you just have in your buffer. All members of the governing board shall be residents of the state of California. And then and then the next sentence would be Supreme Court appointees shall be either and then after either go back to go to the language you already have, attorneys appointed attorneys of members of the state bar in good standing. Okay, sorry, so can't use that language. Appointed shall be either members of the California State Bar in good standing or current or retired judicial officers from the state of California. All right, I was trying to channel Wendy. And so my question is, does this get Wendy's and Marta's vote? And relatedly, do Mary and Eric accept it as a proposed friendly amendment? And by this, we're talking about the 2 sentences just added at the end.
is there a difference between, substantive difference between licensee and lawyer of the state bar? Because I know that hooks into the paraprofessional issues where you could be a licensee when you're not an attorney. And what I really am going for is the attorneys, you know, that must pass the bar and must take the ethical test. So my question specifically is the word licensee.
Yeah,
So
so
remember-
I use licensee because Justice Duker had said member, and you're not supposed to use member because you're no longer members of the bar, you are licensees. So yeah, you guys can substitute that if you want to attorneys and.
I think
The
attorneys would
attorney
be
is
better.
licensed by the state bar.
Yes, that is better. Thank you.
And so it'd be licensed by the California State Bar.
States
All right.
of California.
Okay, thank you.
Thank you.
So now, so Wendy, does this get your vote? Marta, does this get your vote? Wendy, Mary, do you accept it? Eric, do you accept it? And Mary, I guess you and Eric can speak first. Or anybody can speak of.
Yeah, I
For
mean,
that provision, that specific provision, yes, those changes would get my vote.
Okay, so that,
Mine as well.
okay. And so, when you say that specific provision, does the motion now get your vote, I guess is the question.
Yes, because I understand that
Good.
the motion is specifically about the language that we're covering here and nothing else,
No,
correct?
no, the motion
motion.
is the motion is to adopt the chapter draft with the edits that are on the screen in front of us.
Oof,
What-
that's
While
broader.
you think about that, we have comments that I'm going to call on first Becky and then Toby.
Also, Justice Duker, can you confirm that Eric, who seconded the motion, is okay with it? He still hasn't confirmed verbally.
I
I
haven't
know.
either, by the way.
No, I know you
haven't.
haven't,
Thank
and we're
you.
going to get back to that, and any of you can
Okay.
speak up when you want to, because if Mary or Eric says no, then we're going to just erase it.
Just want to observe, make up an observation about the process that we followed here. So the group met and it devised the original recommendation and that passed. And then we revisited it and that passed. And then we did some modifications here, which did not pass. And now we have had a conversation to allow the exact same substance that we just voted down to be restated and voted on again. So I'm kind of puzzled about when we decide an issue is over or when we decide we've made a decision, because we seem to keep revisiting them.
Okay, I think just as anybody on the board, anybody on the committee can say, let's table this, somebody on the committee can say, let's vote now, but without having somebody else yank the chain, I'm the only one who can yank the chain, and I'm trying to finish the conversation as quickly as we can. So I'm going to call on Toby next.
Again, just a technical language issue, current or retired. I think the actual term is active or retired judicial officer of the state of California. I'm not sure what that means. Would it include, a federal judge? Would it include, I'm not sure what a judicial officer of the state of California is.
So active or retired California judicial officer? Is that?
If that's what we want.
Okay. So now let me go to Mary and Eric and Wendy and anybody who wants to speak about whether these new additions are dispositive, whether we're ready to vote, whether you accept the changes, Mary.
I guess, I mean, these are the exact same changes that I already said I wouldn't accept, a half hour ago. So I'm sort of left trying to figure out what to do. I'm not, I mean, I guess, I share Becky's frustration. I mean, we've spent hours and hours on this already. I'm not willing to agree to the residents of the state of California. I will accept the other language, but Eric can, if he's in favor, can try to talk me into it, but we're so protectionist and I don't understand why.
Okay.
Period.
Eric, do you want to speak? And
I actually don't. No, I want to be very
Okay.
quiet.
all right. So there's been a fair amount of expression that we really need to wrap this up, not just from me, but from other members of the committee. The friendly amendments that come after the footnote 6 have not been accepted, so please demote them. That is to say, get rid of, yeah, there you go. So now we know what the motion is. It's to accept chapter 2 as amended by the edits that show on the governing board screen right now that are highlighted. I am going to ask Mimi to call the motion.
Sorry. Okay, so the motion is to approve the language as it appears on the screen, the recommendation, and also approve recommendation 18, which appears on page 1 of agenda item 2A, that approves the partial draft of the report as presented in attachment 1. I'm good? Okay. Where is my voting slip? Okay. Mary Baldwin,
Yes.
Becky Sandifer,
Yes.
Marta Alkenbrock,
No.
Andrew Arruda, Wendy Chang, David Engstrom, Dan Grunfeld, Eric Helland,
Approve.
Kathy Huang,
Yes.
Micah Star Liberty,
No.
Kevin Moore, Wendy Musell,
No.
I'm sorry, I was muted. Yes.
okay, thank you, Kevin. Lucy Rica,
Yes.
Toby Rothschild,
Yes.
Patricia Scutiero,
Yes.
Satya Steinberger, Betty Williams,
No.
Lori Zelon. Okay, the motion carries. 4, 5, 6, 4, 7, 740.
Okay, thank you.
840, sorry, 840.
I wish I could give everybody a break because we've been working hard, but we only have an hour and 6 minutes left in our meeting time, if I remember correctly. I think the meeting's noticed to end at 4 o'clock, right, Mimi? So what I would like to do is I'm going to set a time limit on each of our remaining agenda items. I would like to move to agenda item number 2, ask Becky to present it and to make her motion. We had no written comments on this, so I would hope that the spoken comments will be few and far between, but we'll see. And if there has been no vote on the, and I will call the vote after, we'll end this agenda item at 3:30, one way or the other, and move to agenda items C and D.
Just a sticker, just a point of clarification. The meeting was noticed until 4:30, although I would
Oh, good. We have much more time than I knew. Okay, well then I may or may not move us away from this agenda item at 3:30, or we may or may not even need that long because there were no comments on the draft that circulated, and the material is all familiar in this next draft chapter from stuff you all saw before. So with that optimistic introduction, Becky, the floor is yours.
Thank you, Justice Tucker. So this is a draft of a part of what would be the final report from this committee if it survives, that describes things that we've already agreed to about the way regulation will work in the sandbox. So it identifies 4 different consumer harms. It says that the model of regulation will be proactive. It'll involve an assessment of risk. Entities will be individually authorized. They'll be monitored and have to report on their activities as part of the assessment of consumer protection, and that monitoring will include audits of the actual services that are provided. There are examples of what the risk assessment could look like, although all those details would be worked out when the regulator is created. And there are examples of what the sort of public communication could look like with the badges and things like that. And there's an example of what an authorization order might look like. So the recommendation before the group is that we accept this draft as a draft of our description of what we've already agreed to about how risk-based regulation would work if there were a California sandbox.
And there was one small amendment made in pulling together the chapter from what had previously been authorized and agreed to, and it's just noted by the bracketed initials GB1. And the note that got cut off there is the fact that on this first page, identifying and preventing consumer harm, our original recommendation had started for purposes of entering the sandbox. But in pulling together everything we had, those of us who worked on preparing this draft for you felt that it was appropriate to leave off that in that first paragraph, those particular words. And we wanted to flag that for you because otherwise we think we faithfully captured what you've seen before. Becky, are you making a motion and speaking in favor of it?
I move to approve this as the draft describing these decisions that we've already made.
Okay, is there a second for Becky's motion that we approve this draft?
Second.
Eric has seconded the motion. Is there any further discussion of the motion? Hearing none, I would ask Mimi to call the roll.
Okay, so the motion is to approve this draft as it appears in agenda item 2B.
Yes.
Okay. Mary Baldwin,
Yes.
Becky Sandifer,
Yes.
Marta Alkenbrock,
No.
Andrea Ruda, Wendy Chang, David Engstrom, Dan Grunfeld, Eric Helland,
Yes.
Kathy Huang,
Yes.
Micah Star Liberty,
No.
Kevin Moore,
Yes.
Wendy Musell,
No.
Lucy Rica,
Yes.
Toby Rothschild, Patricia Gutierrez,
Yes.
Sacha Steinberger, Betty Williams,
Yes.
Lori Zelon. Okay, thank you. The motion carries.
Okay, thank you. And we didn't even need until 3:30, as it turns out.
Just to clarify, that was 830.
Yes, 830.
Thank you.
With that, we will go to agenda item C, discussion and possible action on recommendations about the required level of involvement of a California licensed attorney for all Sandbox participants.
Justice Chuker, is because now we're going until 4:30, is there a possibility to take a break? We've been going, I think we've only had probably about less than 15 minutes to break this entire day.
I think that's a very reasonable request. How about we take a 15-minute break and come back at 3:15 to get to agenda item C and points beyond.
Thank you.
Okay, thank you. And thank you, Marta, for flagging that. All right, that was a very well-deserved, if too short, break. Thank you, Marta, for bringing the subject up. We will now, in a moment, move on to new item of business C, 2C. Before we do, I'd like to ask bar staff to make a note that if we convene again in September, we should put on the agenda addressing Justice Zelon's comment about risk-based regulation, because she had a specific proposed amendment to the chapter we just adopted that she was hoping we would make. And we didn't because she wasn't here to re-raise it. But given that she teed it up for us properly and didn't know that agenda item would last until the time she had to be gone from the meeting, let's make sure we give her a chance to make that point and address it if the efforts of this group continue into September. But with that, Bridget, I believe you are prepared to present the work that several of you did on the memo about the involvement of California licensed attorneys in Sandbox entities.
Okay, so this is the memo that you have. It's item 2C. Some of it is you've seen before, might look familiar for those of you that were with us before. We've talked about this a few times in the scope subcommittee, and then I believe the full working group had some discussions about this as well. I've included some background information that we had provided before on this topic, and this is something we know has been of great concern to people on this working group, and also we've heard from the legislature also about how we can make sure that there is accountability for people that are operating in the sandbox. And so the models that I have in front of you just show what the different jurisdictions who do have entity regulation in some form. So Utah, as a reminder, is a sandbox, so they do not specifically require a responsible attorney to be designated for each applicant, but they take it into consideration as part of the risk assessment. The other items the other jurisdictions that are in this memo are Arizona, England and Wales, Victoria. They actually do not have sandboxes. They just have straight ABS regulation, or alternative business structure regulation. So they do require attorneys in some way. They have different names, and I've kind of summarized that for you here. And then I just also, and Canada is in various stages of developing their own kind of alternative business structure regulations. So they didn't have enough at this point to provide specifics on what they do. But I did want to remind everyone of the discussion that we had. So several people, as I said, including members of the legislature, would like to have a licensed attorney, like designated by each entity that is whose license is on the line, basically to ensure that the sandbox provider is providing what they're supposed to be under the circumstances. They're there for resources to, if people have questions, they're ensuring that training is adequate, that type of thing. Other people, when we discussed it, were concerned if you require this compliance attorney, just say a responsible attorney, to be an employee or a manager of the entity, that might exclude. Sorry, did you? Oh, sorry. That might exclude some people. Nonprofits might not be able to afford to have an attorney on staff, or some smaller entities might not be able to have somebody who's actually on staff. So there was some discussion about whether or not this responsible attorney would have to be actually employed by the provider. Some people talked about, as Utah does, maybe it makes more sense, rather than to require that there be an attorney designated, that you would take it into consideration as part of the risk assessment that you all adopted in the last vote that we talked about in the consumer protection mechanism. And then we also wanted to add on here, so basically we teed up these as options for discussion today. So the first option is, as I said, you would recommend a responsible attorney to verify the model, that it complies with California law and the rules established by the Sandbox regulator. They would establish appropriate training and updates for people who are delivering legal advice as part of the provider in the Sandbox. And they would also serve as a resource to give legal counsel when necessary. So that is option one. And in this option, as teed up, just kind of based on the discussion, it has a line in here that says the attorney may, but is not required to be a manager or employee of the provider. And then option two is summarizing the other part of the discussion that we had, which would be more incorporate this into the risk assessment, but not have the requirement. And option three, we added kind of at the last minute here, just because of, as we summarized earlier in this meeting, the State Bar Board of Trustees had approved some potential amendments to the fee bill, one of which would say, attorneys, any provider in the Sandbox would have to be at least 50% owned by attorneys. And so we thought it would make sense as part of this discussion to add that option as well for you all to discuss and think about, and as making a recommendation today. So that's just a summary of what's in the memo, and just kind of a reminder of what we've talked about before and where we are. I'm happy to answer any questions or give more details.
Thank you, Bridget. What I would like to do before we move to any potential action item is to engage in a certain amount of discussion. You all will remember our rules and practices are that those who submit written points ahead of time are called on first, but Justice Elon had to leave. So I just want to read, for those of you who didn't see it, her comment. on this agenda item. As we consider option 1, can we also consider only allowing the lawyer not to be a member of the organization for organizations below a certain size? That way we limit the possibility of information being unavailable to a reviewing lawyer who has no formal relationship to the group. And by formal relationship, I think she means as an employee or manager, but recognize that some groups may be too small to have someone on staff. So that would be, I think, an option 4 that would look just like option 1, except the last sentence would presumably say something like, this attorney may, but for small service providers is not required to be a manager or employee of the provider. And I'm sure someone will say, yeah, but what do we mean by small service providers? And I think the answer is Lori Zeland hasn't told us what she thinks. And at this stage, we don't have an answer because we don't even know if that's something that people want to gravitate toward. But if we could start by a discussion where I'll call on people who I would encourage to have, preface your comments by, I favor option 1, 2, or 3, or I favor an option that would say such and such, which isn't 1, 2, or 3, and here's why. That'll give us kind of a read of the room as to whether or not we need to even start, editing specific options or where where people's views tend to be. Because I think we've talked about this before, and some people may have fairly well articulated views. So if anybody would like to share how they hope the group will turn out on the question of what role a California licensed attorney should take, I would love to recognize you in this discussion. Eric.
So this is more of a question. I guess option 1 and 2, this is not helping in any way, shape, or form, but option 1 or 2, but I have questions. So I guess my first question would be, Lucy, I was playing around on the Sandbox website. I didn't find any sort of entities in Utah that didn't have either weren't owned by an attorney or didn't have some sort of compliance person. So one question, I was just going to throw this over to you because this was, armchair empiricism like last night as I was thinking about this, but are there entities out there that don't have at least a compliance attorney that they're contracting with?
So they don't have to. And Becky, correct me if I'm wrong, but I think we have one entity that, at least in its initial application, this is one of our nonprofits that's doing the medical debt legal advocate stuff. They're not a legal nonprofit, and they're training up their non-lawyer advocates to kind of negotiate medical debt issues for indigent clients. And they are in our highest risk category because they do not have ongoing a Utah attorney in an ongoing kind of oversight role. They had one at the front end to help train up, but they won't have one on an ongoing.
They won't have one. So what they're trading off is they think it's cheaper to comply with the kind of constant reporting relative to doing that with an attorney is kind of the trade-off here. And
sort of what we do is then we, as the quote unquote regulator, play a little bit of more active quality control role.
Because that seems quite reasonable to me, right? That essentially what you're saying is you can hire someone as an attorney who will do that for you, and will, as the regulator, will take a slightly lighter touch because we trust an attorney to do that. But if you don't do that, you're in the highest risk category and you face a much more frequent and comprehensive reporting regime. Okay, I just want to thank you. I appreciate that. I just want to make sure I had that right. And then I guess my last question is for Bridget, which is, if we went with option 3, could you have a publicly traded company that has to have 50%? It seems like that would prohibit. Justice Tucker is shaking her head. Okay, that was my sense too, was that essentially eliminated any publicly traded company. So that's going to greatly restrict the amount of capital that we could, that you could bring into some of these problems if you can't, do this without sort of attorney ownership. Okay, I just want to make sure I had that. Thank you.
Presumably you could have, I'm making this up, but it occurs to me that you could have a publicly traded entity have a subsidiary that would own a portion of a legal practice or something like that. So it seems like there would be indirect ways of getting a public company into the, into a lawyer dominated entity, but I'd want to consult a corporate lawyer before I said that for sure. And I'm not sure that we need to address the issue before us today.
Yeah, it just seems like that's going to make it very difficult to raise capital for some of these entities because I mean, they won't have assets. So getting a collateralized loan is going to be pretty difficult. Most of these startups are, it's a shame Andrew's not here, but I mean, most of these startups are, basically funded through some sort of venture capital with the promise of eventually going public. So it seems like option 3 is going to make this hard for, us to get a lot of the scale we've been talking about, but.
Thank you. Betty Williams.
Thank you. And I don't want to take up this group's valuable time. I've tried to catch up with everything as fast as I could over the past weeks, reading everything. And every now and again, it's just some basic questions. But when I read these recommendations, with these options, I was thinking, are these mutually exclusive? Are we looking to just have ultimately one option? Is one question, which maybe anybody can just nod or shake your head no, or we can have multiple.
I guess I would say that we're looking for one option, but it could be a kludge of 2 of them. We could say option 1 for big companies and option 2 for little companies, or option 3 for if the legal services are provided by lawyers, but option something else if they're not, or something.
And I just a couple thoughts, again, new to this, not involved in the level you guys all are, but I guess to me, it's like if we have to say we're putting something together, but note that it has a higher risk to people who choose to use it, I'm not sure about the quality of what it is we think we're providing. There's something in that just inherently bothers me a little bit, but I also don't know, and maybe Eric's got the, the data to support who exactly is interested in doing this and whether or not there is a collateral problem, if we don't have big corporate funding. Because I was going to say for that option 3, shouldn't it say at least 51% or more than 50%? If we're trying to get more than half, I don't think it would be 50% to be controlled by lawyers. I think that at least should be changed. Anyway.
I can address the question about the higher risk. I can see why just jumping in that sounds very strange. But basically, so what we had talked about before as part of the consumer protection mechanisms and what they have developed in Utah is when people come in, they're assigned a certain level of risk based on their model. So the farther away they are from a traditional law firm, the higher risk assessment, the risk they're assigned. And that means they have higher reporting requirements and that the regulator is much more like active in monitoring what they're doing. So that's what that means. Not like, okay, we're going to just say that you're high risk. Go good luck. Yeah.
So that's more burdensome on a level of monitoring them, certainly.
Right. And it is a higher level. I mean, that entity has more to do than another. So if you have an attorney, you don't have to maybe presumably report your data as often, maybe only quarterly instead of monthly.
Okay.
That type of thing.
Thank you very much.
Marta.
It just strikes me, these 2, the first option 1 and option 2 look to address engagement in an attorney into the entities and how that attorney functions relative to what the entity is doing. I mean, that's what option 1 and option 2 strike me as. Option 3 kind of seems like it's an insert, which isn't really, it's kind of one of these things is not like the other. And option 3 strikes me as not like the others. We're now talking about something that's not necessarily about attorney involvement in the management of the structure and what they're doing, but ownership, which is slightly different. And so I'm just confused. I understand why this option was included given the comments for the legislature. I don't know that it belongs here. I think it's something that we need to address, but I'm really curious as to why it's now put into this chapter that we are looking at right now for lawyer participation. Because go ahead.
That's a very good question, and let me attempt an answer because I thought it was important that we add it. You're right. First of all, we're sort of switching gears now. We're not adopting language for a chapter. We're just trying to see, do we as a group have a recommendation for the form of attorney ownership?
Mhm.
So option 3, you're right, just focusing, I said ownership, I meant involvement. You're right, option 3 could be revised to drop any reference to ownership. It could just be the working group recommends that all providers be controlled by attorneys. Because we don't have to address who owns it. We just want to address what is the role of an attorney. And maybe the answer should be attorneys collectively call the shots. But the reason that ownership and control are both in option 3 is because ownership is the language of the State Bar Board's letter to the legislature, and ownership implies control. So it was my attempt to take the ownership language and say what the consequences would be for control. But you're right, we're not talking about ownership as such. We're really talking about what should the role of the California licensed attorney be. So do you find yourself favoring one or the other of these options or some variant of it?
I'm not quite there yet. I was just more perplexed about, we're talking about with options 1 and 2, something different than ownership. So I just wanted to get clarification as to why option 3 was included, other than doing something that the legislator wants to have us address in this meeting while negotiations are going on.
And sort of for the completeness of it, you could add in your own mind, or if we ever get to a motion could state there will be no requirement of attorney ownership in option 1, and there will be no requirement of attorney ownership in option 2.
Yeah, I don't know that I would be asserting either one of those, but
I thought you might not, but I want to be able to address your comparing apples and oranges. I'm not trying to exclude from our consideration of any of the 3 options attorney ownership. I'm trying to address the broader question of attorney role. Kevin.
Okay. First I'd like to see clarification, because it's kind of related to this idea of having lawyer involvement. Where do we stand now on requiring bonding capacity or insurance of a Sandbox participant?
We have not addressed those. We have not made decisions on either of those issues.
Okay, so my comments are really subject to that, because to the extent or the size of the bonding requirement or insurance requirement, I'm not interested in option 2. I'm not particularly interested in option 3. I want to see some kind of lawyer involvement with option 1. I saw Justice Zealand's recommendation about size. And of course, I asked the question that you recognize, Justice Tucker, that, well, if that's the case, I mean, you're going to ask, what is small, what is large, and where do you draw the line? And I'm wondering, I just don't know whether that's going to be an issue, because some of the participants, as we've seen in Arizona, I think in Utah as well, are national entities that have come in who have lawyers on staff, or they have regular lawyers who are advising them. So that's not going to be an issue, but I think we do want a lawyer who is going to be involved to provide some kind of assurance to the public. And when I say the public, also some kind of assurance to the legislature, which is going to have to sign off on this as well. So my leaning would be some form, not necessarily the language that we have right here. I want to think a little bit more about that, but I would lean more in favor of option 1.
Okay, thank you. Betty, is your hand vestigial, or did you have a comment? Okay, Eric.
This is just a short point, but to Kevin's point, I mean, I think we're kind of all reaching the point that option 3 isn't really address the concern of needing a compliance person, or at least, if not a compliance person, a statement that you go into the highest risk category and are monitored much more heavily. Because I could easily see this going the reverse way, which is a large company that just happens to be headed by a lawyer, right? But has almost that CEO has no monitoring function, right? I mean, in fact, I think we've actually talked to a couple of large companies that have presented here, and I would assume that the ownership there being 51 or whatever percent wouldn't make much difference, because that person isn't going to be doing regulatory monitoring themselves. And it would be odd for a large company like that to not have a compliance officer. But if they didn't, I would think you would then want to put them in the category of high risk and monitoring them much more closely. So I guess the more I think about it, the more I feel like option 3, we almost want to set it aside and say, that the issue of ownership is kind of independent of this issue of, do we need a compliance officer, or are we willing to allow a subset of categories where the sandbox regulator could be the de facto compliance officer through a higher level of monitoring? And that really seems to me to be the 2 choices, right? You have to do the compliance yourself in-house, or we're going to allow you this one option of having the sandbox regulator essentially be your compliance officer. And, to Lucy's point, you could see where a very small entity that didn't do that very often might prefer reporting that to the sandbox entity than, retaining an attorney to be their client, compliance officer. That's, I think, going to be pretty infrequent, right? Most of the time you would want to do that internally.
So you're still of the view that option 1 or 2, or some variant of them, is where you're leaning, but as between 1 and 2, you're not leaning yet?
I would almost, honestly, I would almost do this with option 1 with an exit strategy for entities that, say voluntarily, and understanding that they're doing that, are willing to enter the highest risk category regardless of what they're doing, which means they're monitored much more actively. And that, I think that gets at the what is a small entity, because I would assume no one, no firm would want to do that, sort of put itself into the sort of much higher reporting category if it didn't have to, absent it being a very small firm that didn't think that would be particularly burdensome. So I'm kind of fine with, an attorney compliance officer. I might personally like to have the exit strategy for very small entities, which I think is kind of what the proposal was. It just specified small.
Okay, got it. Anyone who hasn't spoken yet want to tell us what your view is of what role should be required of a California licensed attorney for any sandbox entity? Okay. Enough people have been silent that I'm not sure whether there is a motion that would command a majority, or whether anybody wants to make a motion. We don't have to have a decision on this issue, but if we could have one, it seems like it would be interesting and helpful. Lucy?
I'll just say I liked Eric's suggestion of one with a exit strategy for those who want to opt into higher frequency oversight, intensity oversight.
Okay.
If I could make a motion, it's not going to be for any of these options, given the number of members of the working group still standing. I would prefer to table this motion in consideration of this topic until we have a fuller representation of the working group.
All right. I think we've heard that a motion to table needs to be, should be voted on. So is there a second for Kevin's motion?
Second.
All right. Marta has seconded it. And so we're going to vote on whether to table this this vote, whether to, well, I guess there's no motion to table. So I guess the motion is to move on from this agenda item without entertaining a motion. Is that about right, Kevin?
Sure.
Okay,
Whatever gets us from point A to point B.
I think that's what, the motion is. Marta, I assume you approve of that? And
Yes.
so we're gonna take a vote on that. Starting at the top of the roster, Mimi, if you would.
Okay, Mary Baldwin,
No.
Becky Sandifer,
No.
Marta Alkenbrock,
Yes.
Andrea Ruda, Wendy Chang, David Engstrom, Dan Grunfeld, Eric Helland,
No.
Kathy Huang,
Yes.
Micah Star Liberty,
Yes.
Kevin Moore,
Yes.
Wendy Musell, Lucy Rica,
No.
Toby Rothschild, Patricia Scuttiero,
I'd like to say yes to tabling it until the next meeting. So
okay?
is that a yes? Yeah.
Yes, that's a yes.
Okay.
Sasha Steinberger, Betty Williams,
Yes.
and Lori Zelon. The motion carries 6-4.
Okay, I'm gonna give Eric some homework. And
I was
anybody
going to
who-
volunteer to do the homework, so.
Excellent. The homework is to propose an option.
Yeah.
I don't care whether you call it 1 or 4 or something else.
1.5. There we go.
Yeah, there you go. Just propose something that you think we might want to adopt at our next meeting
Okay.
in light of your comments and those that everybody else made today on this subject.
Will
And
do.
anybody who wants to help Eric can let him know that. Eric knows not to talk to more than half our group, but I don't think that'll be a danger. I mean, on any one subject without open meeting, et cetera. Okay, good.
Thank you.
Kevin, your hand is still raised. Is that vestigial?
Yes.
Okay. Good. Then we'll move to the last agenda item. Discussion and possible action on a standard of care. Like the subject we were just discussing, this is not reduced to the form that it would be a draft chapter. This is at a more preliminary form of, here's some analysis we've done, some proposals we've made, what do you all think? And so I'm gonna call on, I think Lucy with a second from Mary to talk us through this item, and then we will have a more far-reaching, discussion.
Sure. One thing that I would maybe point out is this memo was drafted really sort of directly to try and respond to some of the concerns raised by Wendy, who is not here anymore. So I'm happy to go through it, but I feel like we would just have to do it all over again. So I defer to you.
So what I would say is I think Wendy's not the only person who has some questions, issues on this area. She may be the person who spoke most loudly or clearly, but in any event, I think there are various people who are interested in it. And I think that some of the ideas in this memo may benefit from, our non-lawyer members may especially benefit from a chance to talk about it today, even if we don't vote on any motions. So we can put off the question of whether we're going to vote on any motions, but I think a lot can actually be accomplished by having you talk about the analysis and the considerations, by fielding questions for people who have questions about your analysis and considerations, and then by people who have views already sharing them, even though we recognize that may not, there may be plenty of people who say, yeah, let me think about this till next time.
Yeah, that's totally fair. Okay. All right. So as I said, this was sort of raised directly in response to some of the concerns most articulated by Wendy. And what we wanted to do is sort of take a moment to sit down and lay out the framework and the distinctions between a regulatory regime and the civil liability regime. And we wanted to first sort of stress the fact that, I think it's been said a few times that and I'm not sure how this idea took hold, that somehow there would be no duty of care for entities that are offering services in the sandbox, which I understood to mean the idea was that somehow the sandbox conferred some sort of immunity from civil liability, whether in contract or in tort. And that is not the case. That was certainly, that's never been proposed in any formal way. That's certainly not the intention. So we first of all wanted to make that really clear, that entities in the sandbox are not, the sandbox does not confer any sort of immunity from civil liability. So saying that, I wanted to, I'm trying to scroll down and it's not my screen. Wanted to first just kind of take everybody through the distinction between the regulatory standard and the civil liability standard for lawyers. And for this, I'm going to ask Mary to weigh in because this is actually her area of expertise.
Sure. So, and this, I think this is helpful for probably many lawyers as well as non-lawyers, but there's a distinction between the regulation of lawyers' practice as carried out by the state bar, so that the state bar can undertake disciplinary action when a lawyer violates either the rules of professional conduct or the Business and Professions Code, and disciplinary action affects the lawyer's license to practice. And that's, you know, there's a few other things that the state bar can do, but basically the regulatory scheme of the state bar is that, you know, if a lawyer breaches those duties, the lawyer's license can be affected. On the other side, there's also civil liability, which is generally determined by a negligence standard. And in California, we have a specific, we have a standard of care that applies to lawyers. It's not set forth in any statute. It's been developed in case law over the years from the courts. And it's basically the standard of care is what you use to measure whether an attorney has complied with the sort of duty of care that the lawyer owes to clients. So you look at what a reasonably careful lawyer would do in the same or similar circumstance. That's a rough paraphrase of the standard of care. And that's really that's how negligence is generally determined in the law in a lot of different settings. So if you look through our memo, we describe how that works. So the standard of care for lawyers, where you look at, you know, what another lawyer would have done to determine if the lawyer fell below the standard of care, that is, you know, really consistent with how negligence law works generally. So the question, and if a lawyer has breached the standard of care, then the lawyer is potentially liable for monetary damages in a civil action if the lawyer's breach has proximately caused the client to suffer damages. So we were looking at this to try to figure out, I guess I could turn this back over to Lucy. I guess one more point. So regulation of lawyers by the state bar is done on an individual basis. So if you read the professional rules, they are all aimed at what a lawyer should do or not do. We don't have entity regulation in California. The state bar cannot discipline a law firm. The state bar can only discipline individual lawyers. The negligence standard is also, you know, framed in terms of what a lawyer does or doesn't do. But generally speaking, because of the laws that govern the responsibility of employers for the acts of employees, generally speaking, a law firm, an entity, is going to be responsible for acts undertaken by an individual lawyer who's employed by that entity. So, an entity can't be is not regulated per se by the state bar, but an entity can be liable under our principles of civil liability for a lawyer's breach.
Yeah, so given that sort of framework, in thinking about what we're doing here, what we're proposing to do with regard to the sandbox, the first thing is to sort of look at what we're regulating, which is entities. So it's not, we aren't, within those entities, there are potentially multiple modalities of service, multiple ways that people could receive service. So for example, in the Utah Sandbox, we have entities that are using software, and it's software that could be more DIY, it's sort of like LegalZoom or Rocket Lawyer, where the consumer gets access to forms and but they ultimately are completing those forms themselves, and there's no representative relationship formed there. Or, as we heard from Noella today, her entity actually enters into a representative engagement. She also is using software, but she's also using non-lawyer service providers. And then we also have entities in the Sandbox that are using lawyers. So it's a bit of a different animal. And in thinking about, and it's an entirely new kind of way of thinking about the provision of legal services that doesn't track really directly into the historical professional standard of an individual lawyer providing full representation. Some of the services that are provided may be more like that. The circumstances around the provision of service may be very much like that of a traditional lawyer. Some may be very, very different. And then there's a lot in between. Some may be more like a nurse practitioner type provision, or a registered investment advisor within the context of a bank. And then you've got the software tier. So when Mary and I thought about this problem, and the reason that we laid out the recommendations the way we did, we talked back and forth a lot about it, and we really came to the conclusion that the tort system is actually built to handle exactly this type of situation, in that it's an ex post framework that applies liability based on an evaluation and adjudication of the facts and the circumstances surrounding a particular experience. And so given that, we felt that we actually would like, it actually makes a lot of sense and is probably the most appropriate path to rely on that tort system to do what it does. So not necessarily to impose any specific standard up front when, number one, there's such a diversity of services that may be offered by a diversity of providers within the Sandbox. And number two, that we actually know very little about what could end up happening. And that's exactly the type of thing that the tort system is meant to do. On the back end, an adjudicator will look and say, is what happened here in this particular case like a lawyer? And if so, then the circumstances are such that the professional standard of care should apply. So that, if we can scroll down perhaps to the recommendations, that was sort of how we ended up on this. And one particular distinction is that if folks are uncomfortable with relying on the ordinary standard of care, the common law negligence principles, and want to have something more specific to provide guidance to adjudicators, then it's probably more appropriate to look at, for example, and we cited up above, how hospitals are treated. And hospitals are not a perfect analogy at all. The healthcare system is quite different, but when we're thinking about an entity that is, number one, an entity and using multiple different service providers within that one entity, perhaps that provides an adequate model that could give us enough flexibility, but track, these are the things we want you, entity, to be thinking about as you're developing out your service model. So for example, in option 2, you'll see as part of framing out that standard of care, part of taking a reasonable standard of care is implementing policies, procedures, and systems reasonably necessary to protect its users from foreseeable harm. And that, I think, is quite appropriate but also flexible enough to communicate to entities, this is what we want you to be thinking about. and yet give on the back end the courts enough flexibility to say, in this particular case, that means acting much more like a traditional law firm and traditional lawyers, or in this particular case, we're going to look at how software providers have been held accountable for negligence. So it gives flexibility there. We did feel that holding all of the entities to the standard of care of a lawyer was too limiting and perhaps actually too burdensome on plaintiffs, because there is in some ways sort of a higher standard that has to be met. You often have to bring in expert evidence, not all the time. And there is a shorter statute of limitations for professional providers. So for those reasons, we felt that we should look at creating a